Everybody about ready?
Show on the road.
A lot of people out there.
Guess Lee's not coming?
No, I don't believe so.
Maybe he's phoning it in.
Oh, he did.
We'll go ahead and bring the October 3rd, 2019 Board of Adjustment meeting to order. Madam Secretary, will you please determine a quorum?
Clay
Or take roll
Thomas.
call? I'm sorry.
Clay Thomas,
Here?
Christina Hill. Here. Lee Lawrence. Brad Stanley,
Here.
Kim Toulouse.
Here.
We have a quorum.
Thank you. We'll all stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Large, would you please give the ethics law announcement?
Board members are reminded that if with respect to any matter or any person coming before the board today, you've received a gift or loan, you have a pecuniary interest, you have a commitment in a private capacity such as a family, employment, business, or similar relationship, or provided representation or counseling before an agency to a person or entity for compensation within the last year on a matter being considered, you must disclose that gift, loan, interest, commitment, or prior representation at the time the matter is being considered. And you must furthermore abstain from deliberation or voting on the matter if it is clear that the gift, loan, interest, commitment, or prior representation would materially affect the independence of judgment of a reasonable person. Board members are also reminded that under the Board of Adjustment rules, if you had contact outside this meeting with any persons interested in a matter coming before the board today, you should disclose the nature of that contact at this meeting.
Thank you, sir. Mr. Lloyd, would you give the appeal procedure?
Most decisions rendered by the Board of Adjustment are appealable to the Board of County Commissioners. If you disagree with the decision of the Board of Adjustment and you want to appeal its action, you may do so in writing within 10 calendar days from the date that the decision being appealed is assigned by the Secretary of the Board of Adjustment and mailed to the original applicant in the proceeding being appealed in accordance with Washoe County Code. Please call the planning staff immediately at 328-6100 for information on the appeal procedure and application fee.
Thank you very much. Next is general public comment and discussion thereof. Any person is invited to speak on any item on or off the agenda during this period. Action may not be taken on any matter raised during the public comment period until the matter is specifically listed on the agenda as an action item. Madam Secretary, do we have anyone wishing to speak at this time?
We have no public comment.
Thank you very much. We will move on to possible action to approve the agenda. Is there any comments on the agenda? None? We'll take a motion. Thank you. Mr. Stanley, second. All in favor? Aye. Next is possible action to approve the September 5th, 2019 draft minutes. Before I ask for that motion, Madam Secretary, I did notice one thing upon review of the minutes. It's under item C, which was WBLD 18-105119, the Schmidt appeal. And it was actually on page 10 of 13, and it was the third paragraph down, and I'll just quote this real quick. It says, Mr. Schmidt asked for a procedural question of counsel. Chair Thomas asked Mr. Schmidt to direct his question to him. I don't believe that is actually accurate. Counsel works for us, and I believe I informed Mr. Schmidt that if he had a question, he could bring it forward to us first, and if we thought it was appropriate, I would then ask for counsel's assistance on that. So if we can have the record reflect that, I would appreciate that.
Yes, I'll make that change. Thank you.
Thank you. Are there any other issues with the minutes? Thank you. I'll take a motion or accept a motion on that. Ms. Hill? Mr. Stanley will second it. All in favor?
Aye.
Aye. Motion approved. We'll now move on to the agenda, the public hearing. First up is case number WVIO PLA 18-0379, Hilbert. Before we get started, are there any disclosures from board members? None? Thank you very much. Mr. Geisinger, I believe you are up.
Good afternoon, Board of Adjustment members. Chair Thomas, pleased to be with you today. This is an appeal case of a code enforcement violation proceeding. Case number referenced at the top of the slide here. The picture before you is the subject property outlined in blue. I would note that at the time of this photo, the subject vehicle was not currently located on the property, but I do believe it's placed roughly on what would be the south property line adjacent to that property to the south, which is the right property line as you look at it. A little bit of background. The stage that we're at in this enforcement case, both the code enforcement officer and an administrative hearing officer has determined that there was a violation on the subject property. The CEO determined that a violation existed through conducting a field investigation and determined that there was indeed a semi-trailer on the property visible from public view. The hearing officer confirmed a violation at the conclusion of an administrative hearing, and the property owner has now appealed these findings per their due process rights under Chapter 125 of Administrative Code. Subject property is in Old Cold Springs, so the originally subdivided area of Cold Springs to the southwest of Woodland Village, for reference. It's a 1-acre property surrounded by similar 1-acre properties. And it's not rural, it's a suburban property. Here's a vicinity map of the parcel's location. You can see what I was referencing as Old Cold Springs right there. So up to the right top corner would be Woodland Village. You've got the Border Town Casino off to the southwest there, and White Lake Parkway just below there. So this case began with an anonymous complaint received way back on June 22nd, 2018, alleging three things. One, that someone was living in an RV, which was the case at the time, storage of unregistered RVs, so there were additional RVs allegedly, and that there was a commercial vehicle, namely a semi-trailer, tractor trailer, being stored on the property. As I mentioned, upon investigation, the CEO did confirm that there was a violation. The other two alleged violations were ultimately resolved through other means. And I just wanted to point out that the anonymous complainant has continued to call staff weekly since that time to inquire about the status of the case. Here is a picture of the subject vehicle. You can see circled there in yellow the tires of the tractor trailer. And note that it's kind of got like a step-up shape to it, so it's a particular type of trailer. Another shot from the front, you can see the hoses attached to the front of that semi-trailer, which is a common thing you'll see with these types of vehicles. So what is the violation specifically? It's a violation of our accessory use code, outdoor storage of commercial vehicles on a residentially zoned property. There is quite a timeline to this case that I didn't really want to go through at this presentation. If you can see the entire timeline provided in the staff report and in the attachments, but I'll just cover a couple of highlights real quickly. A complicating factor in this case was that a commissioner for that area became involved in the case and provided the property owner with some incorrect information that they then relied upon, which drug out the case quite a bit. But eventually, a penalty notice was issued on May 24th. The property owner appealed that, and an administrative hearing was held on June 19th, 2019. At that hearing, the county's position prevailed, and the administrative order was issued. There was a lot of back and forth about the type of construction used for a tractor trailer, and I won't go into all the details, but basically, the hearing officer gave the property owner the opportunity to try to legalize the trailer by issuance of a building permit. Staff repeatedly informed the hearing officer that a building permit could not be obtained, primarily because planning wouldn't sign off on it, namely, but also because the building department does not issue building permits for the placement of semi-trailers. So ultimately, the vehicle was not removed as ordered, but on August 20th, the last day they had to comply, the property owners did come in and file an appeal to this board. and that has stayed any further proceedings until a decision is rendered by this board. So here's just a little bit more detail on the code section that's in violation. You can see there on any residentially zoned property, the property is zoned LDS, so it is a residentially zoned property. The subject vehicle does meet the definition of a commercial vehicle based on the definition provided in code, and the exceptions provided in that section of code to the storage of commercial vehicles are not applicable in this situation. Here are those code excerpts, and I've highlighted the specific call-out of a semi-trailer within this definition, so there's really no ambiguity. And then the exceptions there, you can see, home-based business, that's not what we have here, and it's not an RV. So regarding the facts of the case, the appellant has not really ever disputed that the subject vehicle is a semi-trailer, and they admitted that they had purchased a semi-trailer and towed it to the site, and had also mentioned that it was cheaper than buying a cargo container, and that's why they initially purchased it, thinking they could use it for storage. When they were told that it was not illegal use on the property, they reached out to their county commissioner representing the area instead of removing the vehicle, and were provided the incorrect information I mentioned previously in the presentation. We did have discussions back and forth with the appellant, informing them that one county commissioner doesn't make law, that the current code does prohibit this vehicle from being stored on residential property. And then at the administrative hearing, this topic also came up, and the hearing officer also informed them of that, that one commissioner doesn't make law, that it takes a board action. Had quite a bit of discussion about that, but at the end of the day, the current code is being violated, is what the hearing officer found. The appellants then switched their argument from the commissioner said I could have it to, well, actually, it's no different than a cargo container if you take the wheels off, and therefore should be allowed as an accessory use because it's a cargo container. Problem with that argument is that the county code has a very specific definition of what a cargo container is, and it explicitly does not allow what this trailer is, which is a vehicle designed for in-tow trailer highway use. So regardless of the wheels or anything else, this was a semi-trailer towed to the property. It's a highway vehicle, and it does not meet the definition of a cargo container. Here is that specific definition, highlighted in red there, and it's not designed or independent or in-tow trailer highway use. But it also doesn't meet several of these other container or definitions as well. It's not a sea-land container that is built to be shipped across the ocean and withstand salt water. It could not be stacked. That became a topic of conversation at one point at the county commission. Whether or not it can be stacked is really kind of irrelevant. It's just a point that they're structurally different is the point. So just by way of some visual examples, here is your typical cargo container. I'm showing when they're stacked, just to give you an idea. These things can be stacked 10 high in some instances. And then by comparison, here are some typical semi-tractor trailers. The one in the top left is the most similar to the one because it has that segmented thing. So even if you did take the wheels off and wanted to put it on the ground, it'd be probably fairly unstable. And then just to give you some reference, I happened to notice one of these parked on the street one day, so I took some pictures of the undercarriage just to illustrate the difference in construction and some of the complications that would be involved if you actually did allow this to be legal with removal of wheels and placement on the ground. You know, you can see under here that the undercarriage of these things are much different than a car container. They have a hitch. I don't know how you'd remove that hitch. You have all the other components. They're also typically have wood decking on them underneath, which as you can see under here, so that will not last as long just on the ground. And you would also have to remove all of the hydraulic cabling and so forth. So just illustrating some of the differences between the two types of vehicle structures there. Public notice and cab notice. Public notice is not required as part of these enforcement proceedings. The only noticing requirement is to the violator and the appellant. The appellant was provided due notice per the code, and cab review is also not required as part of these proceedings. No other reviewing agencies have been involved in this particular enforcement action. And this is somewhat of an atypical case for the BOA to hear, so I wanted to point out that the BOA is not required to make specific findings like you would on a special use permit or something of that nature. The public record and the body of evidence at all preceding hearings and at this hearing is all that's required to base your decision. Once you make a decision, a written order will be executed per the code and filed with the board and served to the appellant. And if the appeal is denied, staff would request that the BOA consider and discuss what a compliance plan would look like. So removal by a certain date, something like that. Here is a possible motion for your reference, and with that, I will conclude and be available for any questions.
Thank you. Are there any questions? Mr. Stanley?
Yeah, thank you. Chad, there was a mention in some of the dialogue in the pretty extensive packet here about new code and put things on hold until new code arrived. Could you speak to this idea of if there's new code and how that might impact that?
Sure, I'd be pleased to. So what happened is, after the administrative hearing, the appellants started attending the Board of County Commission meetings and speaking during public comment, arguing that the semi-trailer should be allowed as an allowed use for storage and should be considered no different than a car container. They actually showed up at the adopting meeting for revisions to the cargo code container ordinance. And so that kind of confused things because the commissioners were really thinking about car containers, and then they tried to shoehorn in a discussion of the semi-trailer aspect of it as well. And while that dialogue was occurring at the dais, of course, the commissioner that provided the incorrect information was all in favor of allowing these because they thought they were allowed all along. But there was another county commissioner that expressed some interest in allowing these as accessory uses, if you will. But there was not a board action taken to give direction to staff. Staff did respond that there is a code amendment on the horizon where we were going to address commercial vehicles in general, just because of some of the issues that we've come up with. In fact, there was a case before you not long ago about an RV conversion, if you'll remember. So it was more in that realm. This was kind of new information regarding the car container linkage. So it was stated to the board at the time that we would be looking at opening up the code, but that's a bit off on our schedule at this moment, and the end result of that effort is completely unknown. We don't know if the public will come out and oppose such an ordinance. These were just comments during public comment. Does that
Thank
give
you.
Enough? Okay.
Any other questions?
Okay. Thank you very much.
Thank you. Is the owner present, and do they wish to speak on this matter?
How you guys doing?
Good.
My name's Kelly Hilbert. As far as the last part of what Chad was just talking about, we were asked to go to the commissioner meetings by Jeannie Herman. She had talked to a couple of the other commissioners and asked us to come in because this has been like a 4-year ongoing thing as far as changing the codes. So we didn't go in there trying to stir up trouble or get in on something else that was going on. We just came in, one, on request, and secondly, to protect what we have on our property right now. I've never argued that a semi-trailer is exactly the same as a cargo container. I'm asking people what the real difference is as far as what it's being used for on my property. When we bought it, I didn't know there was a code against having it. If I knew there was a code, I wouldn't have bought it. But I bought it, then we found out there was a code against it. In the paper that I have here, it says that they reached out to us numerous times without any reply. That was not true. We reached out to Ms. Beretta over a span of 3 to 4 weeks trying to get a hold of her, and you could only call her before 6 a.m. in the morning to try to discuss things with her. She brought up to me to talk to my county commissioner, which I did, which was Jeannie Herman. And so in November, as far as the semi-truck trailer, because the RV thing was dropped a long time ago. There was nobody living in an RV on my property. I explained that to my commissioner. It's a brand new RV to us. We had the pop out, and it looked like somebody could be, but they weren't. But the semi-truck trailer, Jeannie Herman, I talked to her on the phone about it. She said that there was something going on, I guess it would be last November, and that they had agreed that semi-truck trailers would be allowed on property. They were just deciding whether or not the tires had to be taken off of them or not. So she said I was okay to keep my semi-truck trailer and to wait to hear from her about leaving the tires on it or not, and if I had to move it back a little bit from where it was at. So I went off of what my county commissioner told me. I called Miss Beretta, left a message explaining what me and Miss Herman had talked about, and asked if there was any questions to let me know. Miss Herman actually told me to let Miss Beretta know that if there was any questions that she needed to get a hold of Miss Herman. And we didn't hear anything back from them until whatever the date was, May or something of this year. And then it started back up again. When we went to the county commissioner hearings, they went to go bring up a vote. Herman, the guy that sits in the center and the guy that sits over here, I don't know their names. They were all at least looking at the idea of changing the code or being in favor of changing the code. They asked code enforcement to come back in 2 weeks with a revisal of the code, and in 2 weeks we came back with them, and they had never changed it, so they put it off until February. And so right now we're just sitting there, or sitting here waiting until February to see if that code gets changed, because I really don't want to try to find a place for my semi-truck trailer that I'm using for strictly storage, and then have to go buy a $3,000, $4,000 cargo container if things change in February. You know, if in February, if the code doesn't change, then I have to find a place for it. You know, I'm not going to keep coming in front of people and keep paying fines. But right now, I stand here saying I don't understand what's wrong with having a semi-truck trailer as a container unit. You know, I know it's not metal just like a cargo container or nothing like that. I'm not arguing that. We're not trying to stack it. I'm not trying to ship it over to China or something. It's sitting in my backyard holding tents and, 12 speeds and an old, bed, stuff my wife likes to collect, So if it's an eyesore, I paint it. I don't have a problem with any of that. I just don't see, it's way more structurally sound than a tin shed you can buy at Home Depot. I know that for a fact. So I don't know. We asked for an appeal. We're asking at least to have until code enforcement come back in February to, if the code changes and it works out in our favor, that's great. And if it doesn't, then I guess we got to go a different route. But I guess that's about what I got to say. I mean, is there anything else? I guess that's it.
Second, are there any questions? Let me see if, I guess what I would like you to assist me with is that we have all the information, we have the code as it stands, and it is a semi-trailer, it's not a cargo container. So therefore, by the current code that exists, it can't be on your property. So I guess I'm looking, help me find a way or tell me how this board could take a different course of action. It's been appealed once to the hearing officer that ruled against you because it is a semi-trailer. So I guess what additional pieces of information could you give this board that could change our view? I know that there's a pending possible code change out there, but pending doesn't apply to existing codes at this point in time. So is there anything you can help me with that would open up that door to allow that to remain on your property?
I mean, I don't have a whole bunch of stuff or any studies or nothing like that. The best I got is, off of the information I was given to me by my county commissioner, Miss Herman. She told me I was allowed to keep my semi-truck trailer. I know nothing about the politics in town or anywhere else. I called my county commissioner looking for some help in a situation, and she advised me that I could keep my semi-truck trailer because she said it's been a 4-year ongoing process. They're trying to change things, but she eventually told me we were fine. We just didn't know if we had to keep the tires on it or if we had to take the tires off. And then after that, when we did go to the county commissioner's office, I wish I knew their names. There was 3 that were in favor that day of changing the code. They said that this is something that's been such a long time going and taking up so much people's times that they want something to see done, because they're not hazardous, they're not dangerous or anything like that. Like I said, it's just holding stuff in my backyard, and they're cheaper to get than a cargo container. You know, I don't make a lot of money or nothing like that. So, and going off of that, then the second one they had, they said they're in review, and that all the commissioners asked if we could be put on hold until this code enforcement thing happens in February. So that's the best information I can give you is to let us go out until February and see if they rewrite it, and if they do and it works out in our favor, then I guess we're happy and everybody moves on. I mean, I think there's better things to worry about than what I'm storing my stuff in if it's not falling over.
Okay.
Mr. Chair.
Yes.
Thank you, Mr. Chair. So, Mr. Hilbert, I just want to get clear in my mind exactly what you're asking us for. So, am I to understand what you're asking us is to defer action on the removal or the enforcement of the removal of the trailer until February? Is that what you're asking for?
Yes, sir.
Okay. All right. So then my next question is probably to Mr. Lloyd. Mr. Lloyd, are you aware of any pending action by the Board of County Commissioners to change the code to allow semi-trailers in the code?
We have been directed through the county commission to begin reviewing this very thing and to provide some analysis and bring it back to the county commission. The appellant is correct that the general timeframe is, we're looking at it probably early next year to begin that process. But again, there's no guarantee at this time what action that is going to be. But yes, we will be initiating that process fairly soon.
Thank you, Mr. Lloyd. Thank you, Mr. Hilbert.
Mr. Stanley?
Mr. Chair, I have a question for Mr. Lloyd as well. On our options here, there are affirm, reverse, and remand. Can you go over remand a little bit? I know that it's always an outlier, but it sounds a bit like continuance, and perhaps you could slice that one for us.
I suppose those options might be a little obscure, especially that remanding option.
Yeah.
There is always the option that if there was something to work out, maybe with the hearing examiner, you have the option of remanding this item back to the hearing officer.
If I may pursue that, back to the hearing officer, would that, without saying, think about it until February?
Again, I don't know that would be your first or even second option to remand it back. Again, I believe, maybe I'm looking at my legal counsel for some guidance here, but I don't know that would be the preferred option of this board.
No, I wasn't asking about preferred. I was actually asking what is within the bounds of our choices.
Right.
Yes, Mr. Lodge.
In terms of the options of this board, in terms of the affirmance, reversal, or remand, if there were factual findings or legal findings that this board found were inadequate by the board, by the administrative officer or the hearing officer, that they felt that more factual development needed to be done, this board could remand the case saying we need these factual findings made. For instance, I'm giving a complete hypothetical here. Is this a storage container with wheels versus is this a semi-truck trailer? Or that type of thing would be strictly a remand. Whether or not the hearing officer made correct findings, that's within the board's purview to hear. You have that appeal, that decision, whether that hearing officer correctly interpreted county code based on the facts and law presented to that hearing officer, and you can affirm or deny based on that. If there's some discrepancy in what the hearing officer said that you need more clarification on, you can remand for a further clarification.
one more, please.
Mr. Stanley?
Along this same line of questioning, there were fines associated with this, and perhaps ongoing fines. Does the Board of Adjustments have any input to not only yes, no, but how much? In other words, do we have any impact, and under what choice selection here, would we have any impact, if we have any, on how the extent of fines and so forth?
Right. No, that is not under the purview of this board.
Thank you.
Yes, Mr. Toulouse?
Thank you, Mr. Chair. I know that in past code enforcement cases and in other BOA matters, it is often left up to the board to modify or change an order, if you will, or a motion. So I believe, and Mr. Large, please correct me if I'm interpreting statute incorrectly, that the board has the latitude to grant or to put a time limit on the enforcement action. In other words, we could propose a motion that says, yes, we affirm the administrative hearing officer's decision, and we put a timeline of February 29th, 2020 to remove the offending item.
Mr. Chairman, again, if I may. This board is certainly within the power, it's within the board's power to make a decision saying that I affirm the hearing officer's decision and hold that the enforcement of that decision in abeyance until a specific period of time. I believe that is within this board's discretion.
That was exactly my question. Very succinct. Thank you, Mr. Large.
Any more questions for this gentleman? Thank you, sir. Appreciate that. Madam Secretary, is there anyone from the public wishing to speak on this matter?
Yes, we have Jeannie Harmon.
Jean Herman here. I have been working with these folks for quite a while on their problem. I think that Mr. Hillier has explained his situation very well. I think you're attempting to get a solution for us. The time frame would be excellent if they could have that time frame. And then we did assure him as county commissioner, assure them as county commissioners. And we really, truly figured that meeting would come to a lot sooner than it's going to come. And if it had come, we would have all, more than likely, at least a 4-to-1 vote, would have voted for that. So I just wanted you to know that. And the intent was there. We gave our directions to Mr. Lloyd, and so that's the situation we're in. So I put it in your hands to do the right thing. Thank you very much.
Yes, Ms. Hill.
It's for Mrs. Herman, Ms. Herman. Are you still a county commissioner?
Yes, I am.
Oh, okay.
In second term.
Okay, good. Thank you.
All right.
Any other questions? Thank you. Madam Secretary, is there anyone else wishing to speak?
We have no further public comment.
Thank you. We'll close public comment and bring it back to the board for discussion. Discussion?
Thank you, Mr. Chair. First of all, I would like to disclose that Ms. Herman is my commissioner. I'm in District 5. That has nothing to do, she's not talked to me or approached me about this case in any way, so that there's no undue influence in my thinking process on this case. And I sympathize with the appellant, and I really sympathize with code enforcement probably more than I sympathize with the appellant. Everybody's kind of in a difficult situation here, especially when we have this additional factor thrown into the mix where it's, the county commission may be, and I emphasize may be, willing to change the code sometime in February. So my inclination, Mr. Chair, is to affirm the administrative hearing officer's decision and to extend the time for removal of the commercial vehicle until February 29th, 2020, which I believe is what Mr. Hilbert is asking for. If the code is not changed by that time, Mr. Hilbert, you're out of luck. If it is changed, then all is right with the world. But that would be my thinking in this case. Thank you, Mr. Chair.
Thank you. Mr. Stanley?
I agree with the very clever, I think, idea, and I think a very just idea of extending it until all the smoke is settled, given all the input, both official and unofficial and semi-official. I agree absolutely that code enforcement has done their job and has done an excellent job and has done the proper job. And it's pretty clear that the appellant is not meeting code and their situation is not meeting code as current. However, with all the other input to this, I would absolutely agree that Mr. Toulouse's idea of extending this and the confirmation that that would work from legal is kind of a Solomon's choice there about splitting this one.
Thank you. Any other comment?
No, I think it's a good idea. I'm all for it.
I will, I'll put my 2 cents in here. I guess what I have a couple issues with is, first of all, I do think code enforcement has made their case that this does not meet the current code that we all operate under. That being said, it was first brought to the commissioner's attention back in November of 2018. And that's been almost a year now, and nothing has been done to address that since that time. So we're already at a year's mark out for this. Hopefully in February something can happen, but I've been in government long enough to know that there's usually no quick solutions for things. Other things come up, and there's a level of importances that have to be addressed. So I have an issue with staying it until February and seeing maybe it'll go, maybe it won't. And my other question to piggyback on top of that, and this might be for Mr. Large, and in so doing, I think I already know the answer, but I guess I want it on record, is that what does this do for any other violations that are out there that are very similar? Do those go forward also, or is there a stay if we stay this with the intent of hopefully the commission will do something that it stays everything that's out there?
Mr. Chairman, in regard to that, this is a specific case that is before this board. This is a specific situation. Each of those situations would have to be handled separately. I may make a suggestion in regard to any potential, obviously, you don't have to, you can reject this advice, but there's no telling when the code amendments will go before the Board of County Commissioners. As Mr. Thomas indicated, I might suggest that any possible motion be, instead of a date specific, be a timeline specific to when the code enforcements, if the code enforcements are approved and they deal with the situation. It might be more advantageous, because I don't know if it'll go in February. There's any number of agenda items that go up.
Mr. Large, could you, for my own edification, could you clarify that a little bit? I mean, if you want a time
I'm not-
specific, we would probably say time specific as of, and we'd give a date.
You could give a date, or you could say until the code amendments to Chapter 110 go before the Board of County Commissioners for rejection or denial. What if they went in March? What if they got bumped to a later meeting?
What if they didn't come up ever again?
What if they didn't come up ever again, which is the other issue here.
Okay, so there's a little food for thought amongst the board. Mr. Toulouse.
Thank you, Mr. Thomas. You know, I actually considered that in my thinking, and I am not willing to extend this indefinitely, which I think is exactly what we would be doing if we did not be date specific. So again, my thinking is to go to February 29th. We've heard from the appellant, we've heard from Mr. Lloyd that it may or may not go before February. But the Board of County Commissioners has directed community development to head that direction. Mr. Hilbert has expressed a willingness to move the offending item in February if the code doesn't pass, so that's where I'm willing to go. I do not want to give it an indefinite period of time.
I agree. Mr. Stanley?
Thank you, Mr. Chairman. A question pursuing this timeline, date certain situation, probably for Trevor. As I understand it, just to follow the bouncing ball here, the commissioners had found some anomalies or some conflicting information was brought before them, and they wanted that resolved in a certain way, as I understand it, around these issues, and asked planning to look at it and come back with new code suggestions or new code. Is it?
Yeah, how that works, and thank you for the question. This item was given high priority by our county commission, and they requested from the planning staff to bring this to bring this initiation before the county commission in order to provide further analysis and review. That being said, we anticipate there will be a modification or an amendment of some kind, but we don't know exactly what that is going to look like at this time.
And if I may, is there, were you given a date certain, or do you have an anticipation with some certainty as to when the planning commission would have, or excuse me, the planning group would have the code ideas available?
It was represented at that meeting before the county commission that this process would start around the new year. There was no time certain set, but that was the representation that was provided. Now, keep in mind, at this very moment, we have some staffing issues, and we anticipate that very shortly we will fill those needs. Thank you.
And just following up to put a little point on this, would you anticipate the BCC having the opportunity to review the finished code suggestions before the end of February?
That if we were to begin initiation the start of the year, that would be cutting it fairly closely. Typically, with a code amendment, we anticipate about a 3-month time frame, assuming all things go smoothly. Yeah.
If I may. So would you feel more comfortable with the end of March?
I don't want to get the stink eye from code enforcement, but yes, it would provide, I think, a little more buffer for planning staff.
Thank you.
Let me just say one more thing on this topic. Before us, we have a case that obviously has been proven by code enforcement that there is an existing violation. There is some potential circumstances out there that may or may not transpire. And given that, we're considering setting a date. I guess the other way I could look at this is that we could rule on this with the information in front of us. And of course, I believe the appellant has the right to appeal to the Board of County Commissioners. And if they don't, this is as far as it goes. I withdraw all that, then this will be up for our discussion amongst that.
Sorry, if I may approach the board.
Yes.
Just a clarification on the next step, should an appeal be filed, it would be to judicial court, second judicial court. And then that would be the final step.
Okay.
Chad Giesinger for the record, sorry, planning manager.
No, thank you. I appreciate you clarifying that. All right, any other, Ms. Hill?
It seems like Chad mentioned that weekly he gets anonymous complaints about this from a neighbor. Is that true, or?
Again, Chad Giesinger, planning manager for the record. Commissioner Hill, that's my understanding based on information I received from our admin staff that answers the code enforcement phone. Yes,
Okay.
Yeah, they
So-
call often enough that they're on a first-name basis, even though they're anonymous complainant.
And they calling specifically about this trailer being a commercial use
Yes,
and should not be allowed in this zone?
yes.
Okay, thanks.
Yep.
And bear in mind, this started in June of 2018
Right.
was the first violation, so. No, this is, go ahead and take a seat for just a second. Did you want to ask the appellant a question?
I would like the applicant
Go
to
ahead
come
and
to the,
please come to the podium.
Kelly Hilbert for the record, and from the start of this, I've asked about who the complainant was. They said that I wasn't allowed to know, and I'm fine with that. I know my neighbors. I've walked to each one of their houses. I've talked to each one of them, and not one of them has a problem with the trailer in there or how my yard's set up or anything. So I personally have a question about the complaint in the very first place, but I've talked to all my neighbors. So ain't none of my neighbors calling in.
Mr. Stanley?
you know, there was some question here, we've been talking about the timeline and so forth, and this process apparently began sometime in, I guess, November 2018, sometime in 2018. Can you give us some, there were three, I think, different code infractions, and I believe this is the remaining one, and you've addressed the rest of them. Can you give us some idea of when you took care of those other ones?
There was never a code enforcement to take care of on the other two. They said that we had somebody illegally living in an RV. We had just purchased an RV from Sprad's, has a big tip out on it, so we had it at home. We had taken it camping a couple times, and it has a big tip out on it, like I said, and we had the tip out. That's all we had. If you drive by my house, you'll see the tip out. So I could see where somebody might think somebody's living in it, but nobody was living in it.
How quickly did you respond to their concern about this?
I mean, days.
Okay, thank you.
We made a phone call to her within days.
Thank you, sir.
Thank you.
Any further discussion? I will entertain a motion. Mr. Kalous?
Thank you, Mr. Chair. And again, I really sympathize with code enforcement, and I think they've done their job well. But that being said, I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, Washoe County Board of Adjustment deny this appeal and affirm the decision of the administrative hearing officer that the appellant is in violation of Washoe County Code Section 110.306.35C and uphold the hearing officer's order to remove the subject commercial vehicle by March 30th, 2020, and authorize the chair of the Board of Adjustment to prepare a written order of the decision and file it with the secretary of the Board of Adjustment, a copy of which shall be served to the appellant.
Thank you. Is there a second?
There is, thank you.
Mr. Stanley? All in favor?
Aye.
Aye. Motion passes unanimously. Next item on the agenda is special use permit case number WSUP 19-0018, Foothill Storage. Any disclosures for the board on this?
No.
Thank you very much. Ms. Olander, you are up.
Good afternoon, Julie Olander for Planning and Building. This is a special use permit for the Foothill Storage to allow for the storage of operable vehicles. The location is at 1525 Geiger Grade. And also the applicant is asking to modify the parking standards and not pave the area where the vehicles are stored. This is the location on Geiger Grade. Property has a regulatory zoning of GC, general commercial. Parcels to the east and west have a regulatory zoning of general commercial also. The parcels to the north and south have a regulatory zoning of medium density suburban. The applicant has an existing licensed business adjacent to this location, and the applicant is now, has now acquired this property that we're talking about today. He has already started conducting business at this location, and this is a current code case. So if you approve this application today for the special use permit to allow for the storage of operable vehicles, then the property owner can apply for a business license for this location also. Just want to show you where the two properties are. The one in yellow is where he already has business going on and has a license for that location. And then the location that's outlined in blue is where he wants to conduct the new business. Well, he's conducting business there, but he wants to obtain a license for that location also. The applicant is proposing to have 40 spaces. The site is, he's also providing the 20% landscaping requirement on the location. He's also asking to continue to use King Lane, and I should go back to the other picture just really quick to show you where King Lane is. So King Lane is to the south. So he's proposing to use King Lane as he currently is with the parcel that he has licensed, and the vehicles enter on King Lane and then exit off of on Geiger Grade. So that is what he would propose to continue doing. King Lane is a dirt road. It's considered an unimproved access easement, and the county has never accepted it as a roadway. Staff is recommending that the site be accessed from Geiger Grade and that King Lane be gated as a secondary access. Or the other option is that the applicant could meet the minimum public or private street standards for King Lane to continue using King Lane. The applicant is also requesting to modify the parking standard and not pave the area for where the vehicles are stored. Staff is recommending that all the driveways and roadways on the site be paved, and where vehicles are stored with engines, that those areas be paved, and where they don't have engines like trailers and so forth, that those spaces could be gravelled. Public notice was sent to parcels within 500 feet. This would go before the South Truckee Meadows Washoe Valley CAB on September 5th and was recommended for approval. Various agencies have provided comments which are included in your staff report and are also included in your conditions of approval. Staff is able to make the findings to support this special use permit, which are detailed in the staff report, and I have a possible motion. Also, the applicant is here, and then NDOT is here if you have questions for them, and I'm not sure if engineering was able to make the meeting or not, but if we have questions about King Lane and the use of King Lane versus Geiger Grade, we can try to address those. But the applicant is available, and I believe, if he wants to give a presentation, I'm not sure, but I'm available for questions also.
Any questions, Mr. Stanley?
Yes. Thank you. Planner Olander, there are a number of areas, one of which is the King Lane versus staff saying Geiger, and no paving versus paving on the spots, on the certain places for the vehicles. Are we considering the staff recommendation here, though, at this point?
Julie Olander for the record. So in your conditions of approval, those conditions are stated. So the conditions are stated that the parking would be paved where vehicles with engines are located, and then the other areas could be gravelled. And then also there is a statement in there concerning the use of King Lane and the possibility of paving King Lane if the applicant chose to do that. So those are in your conditions of approval.
Right. All right. Thank you.
Ms. Olander, the properties are adjacent to each other, is that correct? And one right now currently has access off King Lane?
Yes,
And that's a
currently.
storage facility, and then the next one will be a storage facility, but it'll have access off Geiger, is that right?
So what the applicant is proposing to do is continue the access off of King, and then with the new parcel, they would access still off of the existing business location. And I apologize, I did not put a slide up here that would show this more clearly. But they would access in off of the existing business, then loop into the new business, and then loop out through the old business. So the business, the new business would not, and I believe that's correct. No, okay. I'm sorry, I do speak. So the new business will have an access off of King Lane, but then it will access off of, on Geiger off of the old business location. So the new business will not develop a driveway off of, onto Geiger. So let me clarify that again a little. So that if you're if your RV is located at the new business, you'd come in on King Lane, enter into the new business location, and then you would exit out of the old business location.
Still on King Lane.
No, on Geiger, excuse
Geiger.
me. So you go in one way and out the other.
You'd come in on Kings Lane and you would exit through the other existing property out onto
On Geiger. There's really no access off of Geiger at the new location. That building is located in such a fashion that it doesn't really give you access from that, behind it.
Yes, Ms. Hill, go ahead.
Will he be required to merge the properties together to be?
No, they can stay separate.
Okay,
He just has to get a business license for the new location.
okay. Thank you.
Any more questions? Thank you. Is the appellant present and wish to speak? I'm sorry, the applicant. I'll get it. I was still on the last one. The applicant.
Good afternoon, I'm Mark Hain. My wife and I are the owners of Foothills Storage. We'll call it Foothills Storage 1 since that's the original property, and we're going for the SUP for Foothills Storage 2. We are one of only very few boat and RV storage facilities on the south side of town, and obviously with the building of over 3,000 new homes just in our neighborhood within a mile, we feel that off-site parking is critical. We have been in operation at Foothills 1 for over 14 years. It's a small facility. We only have 45 vehicle parking spaces, and I got to see how this thing works. Okay, this is the off of Geiger grade. This is the front of Foothills 1. That's the exit, and then this is the property where we want Foothills Storage 2. We've leased the front for it's a motorcycle repair shop that uses that building. The only really difference between the two properties is that the new property has the building on the north side. Both lots are long and narrow. They're 109 feet by 436 feet, and the new property has 40 spaces. As per the design approved by the board on our original SUP, we have the new entrance to the new property the new property. As for the original, we have the entrance on King Lane and then the exit onto Geiger grade through our existing exit. And obviously the bottom of the page is a south, the new one is on the left side. We enter onto King Lane and then we cross back over at the top end of over onto the existing property, which our lane and we'll get to this a little bit later, but our lane on the original property is all pavers, and then we have gravel where the vehicles are parked. And 90% of that is because of the flood mitigation problems we have out there. Geiger is just horrible for flooding. All the parking spaces are angled north towards the exit for ease of parking and exiting the facility, I think. This is our original facility, and obviously because the lots are really narrow, there's a couple reasons why we have ingress on King and egress on Geiger is because it's so tight for, you bring a 30-foot trailer in and a 30-foot truck. It's awful hard to swing down a narrow lane if you're trying to come in at a 90 or any other direction. We agree with most of the recommendations. A, B, and C on the recommendations we're perfectly fine with. For items D and E, it has been recommended that we only use Geiger as the entrance and exit for this SUP. Our original SUP required us to use King Lane. In fact, originally they required us to use King Lane only, and then we finally got approval from NDOT 5 or 6 years ago. And use Geiger as the egress for the safety reasons, because obviously we're exiting out onto a major highway. King Lane has been recognized as a roadway since 1956. That's at least 63 years of public use. Every property owner on both sides of King Lane have used it since that time. It has its own street sign that was installed by the county. Let's see. There's the street sign, and then obviously we have Old Time Saloon that uses the street as well, and I'll get to that. Because King Lane has an APN, it has become a bit of confusion as to who actually owns it. It is listed as an unknown owner with the assessor's office, and then the treasurer's office doesn't even have it on the tax rolls, as there's no one to collect taxes on it because they don't know who owns it. Old Time Saloon and Nick and Willie's Pizza have access on the west end. Oops, what did I just do? Here we go. This is the backside of the Old Time Saloon. Nick and Willie's Pizza is on the left, and Old Time Saloon is on the right. The roofing, and this is another, both those facilities use King Lane for services with their bringing in food and beverage for their operations of business. And you can tell, and we'll get to the improvement, but I've made the lane wide enough for traffic going both east and west at the same time. The office building on the corner of Kivett even has its own parking lot for employees and clients. And even the Postal Service, whoops, there we go. The Postal Service uses it, has all their mailboxes on both. There's the mailboxes there. The county has stated in writing within a legal document that they will not maintain King Lane. Since then, I have been maintaining King Lane for the past 14 years since we've opened Foothill Storage. Mr. Bacon, who will be a gentleman who will be speaking against us, will say that he has done so. They will say that he's done the maintenance, but as long as we have been there, all he has done is accidentally tear out the city water main while digging holes in his yard. I have letters from my neighboring property owners, which you guys have copies of, and I will read them out loud, and I would like them for the record. However, it is important to note that they verify that the maintenance and safety of King Lane is a result of my actions and consistent maintenance of the roadway. I have ensured its safety for public access for more than a decade. I have even had the Washoe County Road Maintenance Supervisor come out to look at King Lane, and he has even stated it is in better condition than some of the roads that they maintain. As a condition of approval for the SUP, if you would like to recommend a maintenance agreement for me to maintain King Lane, I will happily do so, since I already maintain the road anyway. As far as traffic, we only have around 10 vehicle trips per week in the summer and maybe 3 vehicle trips per week during the rest of the year. The bar and the pizza place average more than that per day. We do have a resident that will be speaking later that has a 25-year-old maintenance agreement that he has had with the original owners of his three properties when he subdivided his property into separate parcels. It is important to note that he does not own King Lane. The maintenance agreement is irrelevant to the use of King Lane by the other owners of properties adjoining the public roadway. In fact, not only does this resident not maintain King Lane and does not own King Lane, but the other 3 owners of the properties that are referenced in the maintenance agreement have had nothing to do with any maintenance, do not pay any contribution to maintenance, and have no responsibility regarding the maintenance. This maintenance agreement of his does not confer standard to prevent the use of the roadway that has been used for more than 6 decades by all the owners with properties adjoining King Lane. In fact, the owners of the 3 properties identified in the maintenance agreement are not the same ones as the original owners that executed the maintenance agreement. Again, the new owners have nothing to do with this agreement and do not claim any ownership to King Lane. As a matter of law, no one can claim ownership to King Lane. It is for the use of all owners along the roadway. As noted, the letters from the King Lane residents, which I will read, verify that I maintain King Lane, are submitted for the record. Those property owners are very happy with what I have taken care of and verify that we are a good neighbor. I'll read the letters when I'm done with the last part. So that pertains to King Lane. We feel there's no way we should be subjected to, it's unfair and prejudicial to discriminate against our business by denying us access to a public roadway that I have maintained. All the other neighboring businesses and the general public have access to King Lane and are using it on a daily basis. We simply want the same consideration. So that's as far as D. And then E, as far as NDOT and their assessment, I was told by NDOT that they cannot express an opinion as to whether it would be safe to use Geiger grade as an entrance or not. They can only verify whether or not it is viable. We have not had any vehicle issues on Geiger because of the way traffic flow is set up and would really like to keep it that way by maintaining the status quo for the new SUP. It will be safer and more logical to be able to use King Lane for our new entrance and continue to use Geiger as an exit. The safety and concern will be alleviated by the use of King Lane, a roadway that no single person has any claim to prevent such use. You do not have any owner of King Lane. You do not have any impediment to its continued use as a roadway as it has been used for all these years. So that's that on that. Landscaping, we're in compliance with the landscaping. As far as the surface on the property, our original one, right when we started, we usually have flash flooding every at least 2 or 3 times a year up there. Everything uphill from us washes down immensely. We didn't really have a major problem until you guys made the people uphill, well, not you guys, but somebody else. There's a property above us that's an acre and a half. They have, in fact, I don't know. Oops. Well, actually, and then here's King Lane. I'm going to just show you pictures of what I've maintained. So, and you can tell it's, okay, and then this is standing at the easement access to the 4 properties that were subdivided by Bruce Bacon, which he'll talk about. This is standing in the middle of the road looking toward our new entrance on King Lane, and you can see we've got it landscaped pretty nice considering it's on a dirt road. And then this is looking at the gate towards Bruce Bacon's house, the house where the gentleman that will be opposing us. And as you can see, the vegetation on his property literally blocks the entire property of ours, so I don't even see why there's an issue with his. Also, as far as drainage, King Lane drains in a southwesterly direction, so everything drains to the southern drainage ditch, and then their road actually drains northerly towards ours, and everything converges at, right at that where the drainage ditch is there. So as far as the main road, or as far as our surface goes, the reason we are asking for a gravel surface is with the asphalt when they asphalted the property up above us, it magnified the amount of water that flows into and over our all the properties all the way down the line, because Kivett Lane, because of the way they've got it designed or dug out or whatever, can't handle the flash flooding, so we all get hammered. And we're really hammered now because of the asphalt that was put up, when they built the plumbing business or whatever it is up the street. So what we've asked for the original one, and then we also asked for one of our neighboring properties upstream. This, let's see okay, this is one of, they've got a storage facility as well. You guys allowed gravel for their parking because at least, it's not necessarily because it's cheaper, but it just slows the water rates down before they get to the drainage ditches themselves. And we came down here and parlayed for that so that we didn't get hammered downhill. And we're basically asking that to mitigate more flooding downstream from us. Right now, we have 3/4 inch crushed hard walk on our new driveway at this time. It binds together like soft concrete and does not create any dust. We would like permission to have a 2-year extension to do a paver driveway like I have on our original one for the main drive. And the reason I'm asking for 2 years is I'm a landscape and paver contractor, and I'd like to just be able to phase it in because it's going to take about a month to do that. And if I can phase it in, when I've got time permitting between projects, I can get the whole thing done, and I'm just asking for a little extra time. I think the gravel road's fine, but I actually like the look of the paver drive better. So that's what I'm asking for. And then as an alternative to paving spaces with the RVs with engines, the problem I have with that is we never know what vehicle is going to come into our facility in an open space. We've been there for 14 years. 90% of the vehicles we have are trailers, 10% maybe are RVs. We've never had an issue with oil or any liquids on the ground. However, as an alternative, I would like to use drip pans underneath which I think is a great idea, regardless of whether you say yes or no. But we would rather use drip pans where the motorized RVs are, because that way it contains if there is any oil dripping off the vehicles, it contains it at 100%. I just use the oil thing as a scale to show how big they are. We can get them bigger or smaller, but I think that one's a pretty good size one. That way we are mitigating 100% no oils or contaminants getting in the watershed or sending anything icky downstream or into the soils. So we have not had any issues in the last 14 years with contaminants. So I'm going to read at least one of the letters since I've got a minute left. This letter is from the neighbor right across from us. I strongly urge you to approve this permit. These vehicles are largely recreational vehicles. We only see them primarily before or after the weekend and traveling directly from Kivett Lane, which is little more than a few hundred feet. It is important to note that these vehicles are not large trucks. Noise from the traffic has never been a problem. The volume of recreational vehicle traffic is negligible and highly seasonal, and generally only 5 or so in a total per weekend. Due to the excellent condition of King Lane, dust is almost non-existent. This is a permit application for an addition to the existing identical business that has never been a neighborhood problem. I have lived at 1535 King Lane for about 5 years now. In that time, King Lane has not only been well maintained by Mr. Hain, but actually improved both structurally and aesthetically. I have always been impressed by the fact that King Lane is in much better condition than any other dirt road in our area, which is to his credit. Without his conscientious effort to maintain this stretch of road, King Lane would look like Pinion Lane, which is barely drivable. All of us in the neighborhood appreciate his work. Any complaints to the contrary are exaggerated and not based on the facts.
Mr. Hain?
Yes.
I'm going to interrupt you here. We all have copies of the letter.
Okay, well, I was just reading them just to make sure that.
Well, we will make sure they get entered in. We've got Moritz, Hughes, I believe Shaw, and Edgington were the ones that were submitted to us.
Pardon me? Yes, yeah, I have 4 letters submitted to you.
Okay, we have.
I was just trying to get everything into that.
Make sure that they're in the record.
Okay, I was just trying to get everything into that 15 minutes, like, hurry up.
For the sake of expediency, we'll go ahead and enter them.
Perfect.
Have them.
Well, I would please recommend that you read them. All the letters pretty much say the same thing. I'm a demigod. No.
Okay, thank you. Are there any questions for this gentleman?
Well, I'm sorry, not for this gentleman, but for Ms. Olander.
Okay.
Okay, do you want me to sit down?
Yes, you can go ahead and take a seat, Ms. Olander. Would you please come back to the podium?
Julie Olander for the record.
Thank you, Mr. Chair. Ms. Olander, the staff report says, and I quote, "King Lane is an unimproved access easement and the county has not accepted the roadway. The roadway is an unimproved dirt access and the maintenance of the roadway has been done by the property owners along the easement." Who's the road belong to?
Yeah, that's a really good question. As Mr. Haynes said, that it's not clear. If you were to look at that roadway, it shows that it's unknown. There seems to be some varying discussions on that, and in putting this staff report together, I could not get any confirmation on who owned the property. My best understanding through our land surveyor is that when the properties, when the parcel was created at that time, there was the understanding that it would be dedicated to the county as a roadway. However, that never happened. The county never accepted it, and the county's not in the position now to accept it, is my understanding also. So it's sort of it's a parcel. It's not. It's being used as a roadway, but it wouldn't meet any of our roadway standards.
So but it is recorded as an easement, correct? Or is it recorded as a parcel?
It's recorded as a parcel, and can I have that overhead? I just want the overhead back up. Oh, you have a little clicker? So if you were to look at the parcel, I'm going to wait and see when Donna gets it back up.
Do you want your presentation?
That would be great. Yeah, that's perfect, Donna, thank you. So as you see where it says King Lane, you can see a white outline. That's indicating that it's a parcel, just like all the other parcels are around there, showing that it's a parcel. So it doesn't show as right away. If I was, if you look at Geiger grade, it does not have that same white outline, really. It's around the individual parcels, and so that's a way to differentiate. You can tell that it's right away versus a parcel.
Okay, I
So the land-
understand.
Okay, so the surveyor, the Washoe County land surveyor basically says that his interpretation or understanding, how he explained it to me was that when it was created, the intent was to have it dedicated to the county, and that process never moved forward for whatever reasons.
Okay, I understand what you're telling me, but let me rephrase my question, or maybe put it in a more difficult way. I don't know. What I'm trying to get at is King Lane a legal easement for Mr. Haynes' property? Is it recorded somewhere that it is a legal easement for him to use?
I'm not aware of a document that shows that. There's some conversation about him having, he has prescriptive rights. That's a legal explanation, a legal terminology of a roadway. If you use the roadway over time, you have prescriptive rights to using that access. But my understanding is there's not a document that has given any of those individuals that are using it the kind of phrasing that you use to use it that way.
Okay,
And I'm just not aware of that. If there is a document that states that, that just hasn't been brought to my attention.
okay. So let me ask you a secondary question. Would the county be all right if we changed condition D as in Delta to the applicant shall use King Lane to enter the property and will enter into a road maintenance agreement with Washoe County?
I'm in the planning department. I would have to probably talk with our engineering staff to see if that's a viable way of moving forward with that understanding of King Lane. I just don't know if I could speak for them. Maybe I'll refer to my planning manager and see if he has had the history to come up with road agreements, that he has more understanding of how that might be managed.
So, and I understand the point of view of planning, and here's where I'm struggling, to be honest with you, is we don't know at this point if King Lane is a dedicated easement. If it's recorded as an easement, he may have prescriptive rights. He may not have prescriptive rights to use it. Who knows? So 5 years from now, somebody could come in and say, I'm going to buy this parcel because it's a parcel, it's not an easement, and the county hasn't accepted it as a roadway. So, Mr. Hayne, I'm kind of at a loss to change condition D because we just don't have enough knowledge about King Lane to change that condition. That's where I'm coming from. So thank you, Ms. Olander.
Mr. Deleuze, one other thing I noticed in the staff report too is that, and I believe we have a representative from NDOT here, but it says the Nevada Department of Transportation is supportive of allowing access for the entering and exiting the site from Geiger grade. So I don't believe that becomes an issue if NDOT is acceptable to those terms, so. Mr. Stanley?
Yeah, thank you. A question for Planner Olander. There's an item E under the Washoe County Engineering and Capital Projects headed by Leo Vesely. And it asks, if I'm reading this correctly, that you need both legal access and the right to maintain and improve. And that is a condition that
Correct.
he
That is a
suggests.
condition if they want, that the usage of King Lane has to be established by this applicant, that they have access to it. That was one of the reasons initially that I was trying to move to have it off of Geiger grade, because King Lane seems to be no man's zone. No one can identify what it is and how to use it. Engineering, their approach was to either, to provide that, but also if you wanted to continue using King Lane, to bring it up to Washoe County standards, which then we could then have it dedicated to Washoe County because it would meet our standards. They're both very cumbersome to do, so and staff understands that.
But if I may, under the current situation, there's essentially no way for this condition to be met, is that correct? You can't establish legal right.
I cannot at this point. I think that maybe after further, maybe research, it might be possible. That's the reason that if we could get King Lane established as a, bring it up to public or private road standards, then it could be dedicated to the county, and possibly then we would have that documentation. We could moving forward it that way.
To pursue this a bit, I don't mean to beat a dead horse, but are you suggesting then that King Lane not be used and Geiger grade only be used until the King Lane status is resolved one way or another?
That was my initial approach in moving forward with this application, was to try to have the applicant use Geiger grade, because that was clearly, that's a public right-of-way. It's designed to use, to manage commercial traffic, and I understand the challenge it is pulling in and out of the site. However, the challenge we have with King Lane, they both have challenges in their own way. There's not one clear one that works the best. The only thing is Geiger grade is public right-of-way, so he can have access. NDOT will allow him to have access. He has access currently off of Geiger grade. It would require him to reconfigure how he accesses in and out of the properties. I understand that is also would be a burden to him to an extent, because it would require him to reconfigure not only the property that he's now acquired, but also the other property that he's had for quite a few years.
Gotcha. So agreeing to this, or putting forth the motion as you suggest now, in its current conditional status, suggests Geiger grade only, King when resolved, or remain
That could be an
silent on
option,
King?
yes.
Let me just intercede here. It's actually in the conditions. Her staff report with conditions say that access is through Geiger grade. So that is her recommendations. So it's really.
Thank you, that's what I was
yeah,
looking for.
King's Lane is out of the picture.
King
By
Lane could
staff
be used
report.
as a gated secondary access for emergency purposes only.
Mr. Chair.
Yes, Mr. Lewis.
Ms. Olander, would the county have any objection if we changed condition D, and of course this would also be subject to Mr. Haynes' approval, if we changed it to read, the applicant shall use Geiger grade to enter and exit the site, and King Lane shall be gated and used for emergency access only until such time as King Lane's legal disposition as a right-of-way or legal easement can be established?
That would be another option. The challenge we also have is King Lane is not, it's not only the legal status, but King Lane is an unimproved road. Usually, typically, commercial vehicles use a roadway that meets county standards. So we could, even if we could, get King Lane, the ownership of King Lane resolved, we still would be using a dirt road accessing a commercial site. Again, that is up to your purview to decide to do that or not. Typically, we don't have commercial vehicles accessing. I mean, it's happening currently right now, but that's not typically how we allow commercial sites to be accessing off of dirt roads. So that, again, that's available. That's an option, another option, available option.
Okay. Mr. Hayne, would you be amenable to a condition of approval that read as I just stated?
Let's bring Mr. Haynes back to the podium.
Mark Haynes speaking. No, in a word. Like I says, our original SUP required us to use King Lane as both an ingress as an egress until we got approval from NDOT, and then they demanded that we use King Lane as an ingress and Kivett as an egress. And again, as I stated before, as why would I be singled out as the only commercial business or anybody not allowed to use King Lane as a access road when the entire general public is allowed to use that road.
I understand your point, Mr. Hain, but we're not talking about everybody else here today. We're talking about you.
I understand that, but I'm just looking at the discrimination aspect of it, and it's like, I go there, do you guys have the legal right to discriminate against a business owner to use a public road? And it is an easement, but it does state in a lot of the documents that it is a road easement. It's not just an easement, it is a road easement. And again, it's been used as a road since at least 1957. I've gone back into the records. I've been down at the, right here, at the records. I've talked to the people at the the treasurer's office. They were, just to give you a little bit more backup on it, they were spinning the wheel with property taxes on it up until 2018, and then they finally went, nobody's ever going to come forward and say this is ours. So that's when they washed it off the books and said, it's just an entity out there that is used for whatever it's used for.
Okay, thank you.
Mr. Haynes, before you leave, a couple things. First of all,
Yes,
the
sir.
board really is not looking to discriminate against you in any way.
No, I understand that.
I just want to, let me
Okay.
make sure we're on record. You threw that out, that you would be discriminated against. I assure you that is not our action here to find some sort of discriminatory actions to take against you. What we'll do is we'll make our decisions predicated upon the information that we have in front of us, and we'll try and make the best sound decision we can. If it's in your favor, so be it. If it rules against you, so be it also.
Okay, well,
Okay, that being said, I'm going to move away from that now.
Okay.
That being said.
all right.
It's requested that you also asphalt that area, and you said the majority of the stuff that you have basically doesn't have an engine on it, but you do have some
Yes, sir.
that, okay, so what about a percentage of that lot be asphalted?
Well, like I said, the main road, we don't want to asphalt it. We use pavers I'm a paver contractor. Pavers are permeable. They help with water flow. That's another reason why we like to use pavers. Like I said, our original, and I could click the pictures up, but our main road is pavers, and then everywhere where the vehicles park is about 4 to 6 inches of gravel. If we are required to have a certain percentage of parking spaces dedicated for motorized vehicles, it kind of limits us to who and what would be allowed, who and what would be able to park there, because we don't know at any given day whether space 26 is moving out with a trailer and then somebody comes in with an RV. That's why I was suggesting, instead of having to pave any yet, if we use those pans, which, like I said, me personally, I think they're a great idea, but that would eliminate a lot of problems with, the more square footage we pave, the more water we have problems with shedding downstream.
What percentage of your operation currently, the one that's allowed, has vehicles with motors in it?
I have 4 out of 40.
4 out of 40?
Yes, sir.
Okay. So you have 10%?
Yes.
Okay, all right. Are there any more questions for this gentleman?
Can I say something? I'm his wife.
This is my wife.
Okay,
I'm Melanie Hain, and I just wanted to say, the access road, I just wanted to explain, because the one we're trying to get the new SUP on, the first third of the acre on Geiger is a mechanic shop, and so I don't know where we would have an ingress and an egress on that new property, which means we'd have to use our old property, and we only have an egress on that property to Geiger grade, and I don't know if we had an ingress and egress, that's a lot of traffic coming in. That would be traffic just coming in onto the old property, whether it's going onto the new one or not, but we would have no access from the new property as an ingress and an egress. And we're only asking for access to the new property just as a ingress, so no egress. And we're really worried about Geiger grade because it is a highway, the traffic on there. They go so fast, and to have an RV or a truck with a trailer, they're gonna be stopping traffic, turning in, and we thought we eliminated, any traffic, and the flow of traffic, we weren't stopping any traffic having it that way. And also, I forgot what I was going to say on that side, but we were just using that one other entrance for those 40 vehicles, not even the other 40. So it's only for 40 vehicles, or, trailers, as a ingress and no egress. And that's all we're asking for King Lane. It's just those 40 vehicles as an ingress. And then we will use our old property as an egress, and then that eliminates all the traffic.
It
Okay.
eliminates one more.
All right, thank you, we appreciate that.
Thank you.
May I state one other thing that you brought up after I had sat down? NDOT did say that it was okay to have an ingress egress, but again, they are not allowed to voice an opinion whether it is safe or not. And, you know, because like I said, I talked to a couple of the supervisors over there, and they told me that. They said, we cannot have an opinion whether it is safe or not. And therefore, even if it's viable and unsafe, they have to say, oh, yeah, it's viable. So I'd just like you guys to take that into consideration as well.
Okay, thank you. Madam Secretary, do we have anyone from the public wishing to speak on this matter?
We have Bruce Bacon.
Thank you.
Hi there, my name is Bruce Bacon. I live at 1530 King Lane, which you can see is parcel 09, and directly behind the proposed SUV storage. I've got 3 minutes. There are so many inconsistencies and false statements, incorrect assumptions, and downright, how do you say them, embellishments that there's no way I can address them in 3 minutes. I apologize. I thought my letter to the cab would make it to you before it did last couple days. So it's quite detailed and complicated. It took me several days to write, and it addresses many issues. So I'm going to address 3 points. I've got 2 minutes. Number one, this SUP of 2006, which Mr. Hain is piggybacking on, was not properly completed. Several provisions deal with NDOT. NDOT has never received an application from Mr. Hain dating from 2006. Washoe County review of the current 2019 SUP is inadequate, as it does not address the improvement for commercial use. This road should have been paved in 2006. And the other thing is, the Washoe County Standard Report calls this a vacant lot. This is an illegally operating business for over 1 year. It was graded without use of a building permit. It's been bulldozed, lack of a better word, by Mr. Hain through the whole process. So I object on the basis of Article 2 and Article 4. First thing he did was fill in our drainage ditches. And you want to see why King Lane looks, I went out and redug them again. I am required to do it by this road maintenance agreement. It's pretty hard to live up to a road maintenance agreement. I dedicated to Washoe County a 25-foot strip as a condition of a parcel map. This thing needs to be addressed. It needs to be continued until Washoe County can figure it out. Thank you.
Thank you, Mr. Baker. Madam Secretary, is there anyone else wishing to speak?
We have no further public comment.
Thank you. If I can get, is the representative from NDOT here? Excellent, thank you.
Richard Ojevolk, can spell it again. I've done it once before. I do it often.
You need me to spell my name? Ojevolk? I've done it before. So,
If you just fill out.
do I have a card?
one of
Yeah,
those.
I can fill out one of these.
Thank you.
Let me get it, sorry. You can just call me OJ. Richard Ojevolk, or OJ, NDOT District 2 Traffic Engineering Supervisor. Questions?
Well, thank you. OJ, just a couple questions. I noticed that within our staff report, it said that that you were notified, and evidently NDOT, I should say, is in approval of access in and out of Geiger Grade.
Well, yes, if Kings Lane cannot be used, the applicant becomes technically landlocked by NRS, we have to afford him access if he is landlocked. The issue's come up several times along Geiger Grade, circled around this road. Lot 017-15101, same issue was posed. We gave him a full access driveway. The subdivision is proposed just to the west of there. Same thing, and also just because of the other tenant or the other landowner across the street who's putting in a single family. We have to afford them a driveway because they're all technically landlocked. So, and that's by NRS.
And when you are conducting your research on that, is there any consideration given toward safety issues, or?
No, there are. You know, and the things, like I said, we don't issue an opinion, but I went back and I reviewed the crash data. Crash data in this vicinity is nothing that would raise a critical issue with us. There have been crashes from the period of 2015 to 2017. There was 14 crashes, of which 8 were injuries. When you go through and calculate the crash rate, it is within acceptable levels, lower than what is the average crash rate, which would trigger a concern on our part, so it's not. We do have access management standards. However, this road, just because of the nature of it, the 108-foot lots, is that it's, for us, it's an entire deviation. We can't meet, because the lots are set up at 108 feet and that they're commercial lots, we would, you know, we would have greater degree of spacing that could be afforded every individual property owner, so then we are hence landlocking them more. We have to, that's a policy versus the landlocking is an NRS, so we have to adhere, that takes precedent over it, so we have to afford everybody access.
And can you clarify when you say your crash data, how big of an area, or what are you talking, are we talking, when you say you're doing that, is that right in front of that location?
I did
Or
it
is that given
localized for about the mile right in front, basically the mile in front, extending. If you look, if I centered it on there and I went about a half mile in each direction, and like I said, there was approximately 14 crashes from the 2015 to 2017 period, of which 8 resulted in injuries. No fatalities.
Okay. Thank you. Mr. Stanley?
OJ, two questions, please.
Yes, sir.
First, following on that safety issue in your study, the applicant maintains, as I understand it, that their situation may be different because of the length of the vehicles and so forth, articulated vehicles and that sort of thing. Do you have anything else in that area that is similar, or how does that affect your research and your study?
There's, again, the lot 01 it's a mini storage. I guess that doesn't require an SUP. I don't know what kind of, but there's going to be large vehicles going into the, moving vans and stuff like that. The subdivision further to the west, it's a subdivision, so people will have trailers and landscaping and other things such as that. One thing I will bring up also is that this portion of the road, along with improvements to toll and all that, were a lot of the decisions we made were based on the LRTP that showed Geiger in this area being upgraded in 2021. It's been moved out to 2027. And so it puts us in a rock and a hard space. We are, but we're bound by laws to approve stuff, and so that's, that's what we continue to do, because we can't deny access, especially if they're landlocked.
And a question related to this discussion. Do you have any opinion
Can't really opinion.
do you have any opinion as related to Kings Road?
you know, we would always love secondary access because it takes the burden off the main roads. But it sounds like it's a very complicated legal issue, and we can only react to the, you know, we don't do land use, like I said, the 108-foot lots. If we would much rather they be 500-foot lots, because then we could get driveways spaced in better. But we have to deal with the way the land lays, and so we have to afford access. If somebody's landlocked, then we have to afford them access. That's an NRS.
Thank you.
Any other questions? Thank you, OJ, we appreciate that.
Oh, you're welcome, sir.
With that, we'll go ahead and close that and bring it back to the board for discussion. Mr. Stanley.
In reading all the material and listening to everyone, it's a difficult issue, obviously, but Kings Road doesn't, or Kings Court, Kings Lane, seems so legally ambiguous that you can't meet the findings or can't meet the recommendations using Kings Road. So are we looking at adding that as, so I would recommend not adding that as, or not allowing that. And if we're voting for this, for approval of this, that we stick with Geiger grade only, and until the King's access is resolved one way or another.
Yeah, I'd just like to say, Mr. Chairman, that's the way the staff has written it, and I think that's the way to approve it, and that's the way NDOT sees
Agreed.
it happening. And, you know, if it's just a parcel, Kings Lane, you know, it's just a parcel. It doesn't belong to anybody, and they can't really give permission to access from
Correct.
that area, yeah. So they either have to change their layout so it works for Geiger grade.
Mr. Toulouse?
Thank you, Mr. Chair. I would agree with Ms. Hill at this point. We can't, there's not enough evidence, and I'm not satisfied in my mind that King Lane is a legal access. Nothing's been presented to me here other than Mr. Haynes' word, and I'm not questioning your word, but I need some sort of documentation that it's a legal access before we can either change the condition of approval. So I'm at a point where we approve it as the staff has written it.
Yeah.
Thank you. If we have no more further discussion, I will accept a motion.
I would so move.
Oh, Julie's talking.
Excuse me, Julie
I'm
O'Leary
sorry.
for the record. I just also wanted to have a comment about the paving or not to pave the area. So I would appreciate some direction on that also.
I believe in your conditions, you said it had to be asphalted. Is that correct, Ms. Olander?
If they have a motor.
If it has a motor.
Yes, and so, yeah, we would ask for pavement.
And that's based on because of the leakage of fluids, I'm going to assume, is that
Our
right?
code requires paving all parking lots, so it is either cement or asphalt. And I would ask my planning manager if he would, so he's asking also to put down pavers. And so I'd also ask for it, you have the ability to modify the requirement of the cement or asphalt. So I'd also ask if you are amenable to the pavers, that you make comment that he can use pavers instead of asphalt or cement, because according to code, is very specific. It's asphalt or cement. So if he wants to use pavers, I would ask that you would make a comment according to the use of pavers.
If I could jump in also, and
Pavers you
sorry.
can't plow.
1 second.
And this board does have the authority to vary certain standards through a special use permit. It's written in Article 810. And so if you decided to allow for pavers, it would require varying the concrete asphalt standard per parking standards.
Mr. Toulouse?
Thank you, Mr. Chair. Ms. Olander? I meant to bring that up earlier, I apologize, but is the county okay if we change condition 1G to read, insert the word pavers instead of paved spaces?
I think I'm going to ask my planning manager his take on that. If and that is your, like he explained, that is your ability to vary that. I don't know if he has a further comment on use of pavers.
I'm asking for your professional input. I know we have the ability to modify the condition of approval. I'm asking for your professional input as a planner or Mr. Lloyd's professional input, what your thoughts are.
I think I'll ask my planning manager to give his professional input here on this one.
And unfortunately, there's nothing in code that I can point to. I think it may be a preference that this board may choose, if you so desire, to go with pavers. I don't know that pavers functions in the same capacity as concrete or asphalt in terms of environmental protection. I know that you see often pavers used on residential driveways fairly often, but we don't typically see those for commercial type operations, and there may be a reason for that. If you wanted a professional opinion, I would probably seek it from somebody that has a little more experience, maybe from our engineering staff in that regard.
Okay.
Thank you. Mr. Pelham?
Yeah, that's fine.
Do you have anything to add specific to this question? You were hovering over us there for a moment, so I thought you might.
I apologize. For the record, Roger Pelham with Washoe County Planning. I was trying to whisper in my manager's ear that in my experience, because concrete pavers are made of concrete, I believe that in some cases in the past, we have considered that to be an equivalent standard.
Thank you for
I
that.
apologize for the interruption.
No, that's fine. It helps us make a better informed decision. Ms. Hill, did you have a question?
Yeah, I was going to say, in my experience, pavers, I don't know if it snows there, but if it does snow, it's not conducive to plowing snow. They get ripped up and chewed up and stuff, unlike smooth paving, because they're not secured, and they get caught, and it makes a big mess. So I wouldn't think it'd be appropriate for commercial use pavers, but he's a paving contractor, so.
Okay, thank you. Any other further discussion on this? And I would assume, and I'm just going to, this was from testimony given by Mr. Haynes, that we talked about that it has an engine, vehicles with engine. His current facility has about 10%. So if we add another 10% to this thing, we would probably be, either you can make it, let's say 25% of pavers, and that would cover both lots, and that would kind of cover that issue that was suggested by staff. So, but I don't know if you want to put a number on it, so.
Also, concerning the runoff of pavement, the runoff can be contained if you install and construct drop inlets and certain drainage facilities that have the capacity to deal with the water runoff of pavement. So that's kind of a non-issue. I didn't even to deviate from pavement just because of the runoff of water isn't really an excuse to not have pavement. Because you can still mitigate that runoff with drainage improvements.
Mr. Stanley?
Okay, so for the board here, are we to understand then that, as has been brought to our attention several times, that the use of Geiger is the current motion?
Yes.
And the use of paving is the current
Yes.
motion? And no percentage is included in the current motion of areas paved or?
No, the areas to be paved, the rest are only for vehicles that have motors.
Motors.
The rest of it can be gravel.
Understood. So the question about 25% or 10%, is that an estimate that we are to make here?
No.
A point of clarification. First of all,
Please.
there is no motion on the table, so this is just open to discussion. And within staff recommendations, staff recommends that access be on Geiger grade. Staff recommends that asphalt be used basically where there are engines to be parked. And I don't know if there was a third question you had there, but I think
There
that
was not.
covers those two.
Those are the two.
Okay. Any further discussion? I'll entertain a motion. If someone wishes to make one.
I will make a motion.
Mr. Stanley.
Yes. I move that, after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, the Washoe County Board of Adjustment approve with conditions special use permit case number WSUP 19-0018 for Mark and Melanie Hain, having made all 5 findings in accordance with the Washoe County Code Section 110.810.30, including consistency improvements, site suitability, issuance not detrimental, and effects on a military installation.
Thank you. Is there a second?
Second.
Ms. Hill, second. All in favor?
Oh, I'm sorry.
Aye.
I'm sorry, can we back up with that motion? Did that include the variance to allow for pavers or not? Maybe I missed that.
No, it did not.
No, it did not. Okay, thank you.
And motion passes unanimously. Is that right? We took a vote on it, right? All right, well, next item up on the agenda is administrative permit case number WADMIN 19-0019, Incline Village Pumpkin Patch. Kirschenman, Ms. Kirschenman. If I didn't butcher your name.
No.
Okay.
Sophia Kirschenman, Washoe County Planning and Building, for the record. Pronounced my name right. Good afternoon, members of the board. So this item is probably a little bit more straightforward. This is to approve the 40th Annual Incline Village Pumpkin Patch, which is an outdoor community event, and the associated outdoor community event business license. The event is to take place on October 19th from 11 a.m. to 3 p.m., with setup expected to begin at 7 a.m. and tear down to be complete by 6 p.m. The applicant anticipates a maximum number of 540 participants, most of whom will be small children and kids. It's a family-friendly event. This is the 40th consecutive year of the event and the third at Incline Park. It's a fundraiser to raise money for the Incline Village Nursery School, which is a nonprofit preschool. And the event is always held at an Incline Village General Improvement District or IVGID facility, but the specific site is always based on availability and IVGID input. So Incline Park is located just south of Tahoe Boulevard and just north of Incline Way in Incline Village. It's a roughly 18-acre park, and this particular event will take place on Field 3, which is the lower of the fields pictured here. Here's the overall site plan, maybe a little bit difficult to see from there, but the yellow, or where the pitcher's mound would be, is the pumpkin patch and pumpkin sales area. The stage and restrooms will be down sort of in the bottom left-hand corner. Those white boxes depict the raffle areas and the vendor locations. Those purple circles depict the event activity locations. And those event activities obviously include the pumpkin patch. There's also live music, carnival games, pony rides, food trucks, etc. The North Lake Tahoe Fire Protection District is aware of the event and is available to provide services if necessary. The restrooms are available on site. All trash will be removed post-event. Water will be supplied through Waste Not. It's an IVGID program, so they'll provide drinking water stations. Additionally, there are 150 available parking spaces, both at Incline Park and the adjacent Incline Middle School. And there's also open parking along Incline Way and Southwood Boulevard. Additionally, our Washoe County engineering staff did review this application and submitted several conditions of approval related to parking. They have requested that the applicant submit a map showing all of the parking areas and also letters from both Incline Middle School and from IVGID stating that it is acceptable to utilize their parking lots for the event. Notice was sent to 176 affected property owners, and this item was scheduled to be heard at the Incline Village and Crystal Bay CAB meeting on September 3rd. There wasn't a quorum, but the applicant did briefly present the item, and no comments were made in opposition. Those agencies which provided comments did provide comments in support of approval of the proposed event, and staff was able to make the required administrative permit findings. We are recommending approval today, and here's a possible motion. I'm available for questions, and the applicant is also here for discussion.
Thank you. Any questions? Thank you very much.
You're welcome.
The applicant present wishing to speak on this matter? No? Come up to the podium. I have a question for you real quick.
My name is Nicole Sterling.
Thank you.
I'm the director of the preschool.
Just the quick question I have is when it talked about parking spaces, it said 90 would be available at the adjacent middle school, but have you obtained the letter from the school yet?
Yes, we have. Sophia has it.
I'm done, thank you.
You're welcome. Any other questions?
Any other questions? Thank you. Madam Secretary, anyone wishing to speak on this matter?
We have no public comment.
Thank you. We'll close public comment, bring it back to the board for discussion. Any discussion?
This is a fabulous event, happens every year, and I'm really bummed I'll be missing it this year. But it's the best thing that happens in Incline every year, so.
Excellent. Thank you, Ms. Hill.
And Incline Village Nursery School is the best, so.
Thank you very much. With that, I'll accept a motion.
I'll make a motion.
Ms. Hill.
Let me get to it here. Okay. I move that after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, the Board of Adjustments approve administrative permit case number WADMIN 19-0019 for the Incline Village Nursery School, having made all 5 findings in accordance with the Washoe County Development Code, Section 110.808.25, consisting of consistency, improvements, site suitability, issuance not detrimental, and effect on a military installation.
Thank you, Ms.
Thank
Hill.
you.
Is there a second?
Second.
Mr. Luce, second. All in favor?
Aye.
Motion passes unanimously. With that, we will go ahead and just take a 5-minute recess, and then we will be back. are back in session. All right, next item on the agenda is administrative permit case number WADMIN 19-0016, DeMartini Garage. Ms. Kirschman, I believe you are up.
Yes, all right. DeMartini Garage. So this item is a proposal to construct a detached accessory structure with a larger building footprint than that of the main dwelling. The main dwelling on the property is 10,800 square feet, while the proposed 25-car garage would be 9,000 square feet. This is a 5-acre parcel. It's located just west of Lakeside Drive on Kinney Lane, and it's in the high-density rural regulatory zone, as are the surrounding properties. So here's a site plan. You can see the main dwelling is sort of in the upper left-hand corner, or northwestern corner of the property, while the proposed garage would be at the lower southern portion of the property. The proposal does include the removal of an existing barn that would be replaced by the proposed garage. Shows it a little bit closer up. It's important to note that there is a pond directly adjacent to the proposed garage area. This is important because the applicant is proposing to construct a levee, a temporary levee, in the pond. Water would then be removed from that area so that they could build footings for the retaining wall that would support that sort of deck or porch area above the garage. And then once construction was complete, the levee would be removed and water would refill that area. Additionally, full grading plans will be required when the applicant applies for building permits. Grading permits may also be required depending on whether those grading thresholds are exceeded. Here's a floor plan. As I mentioned, this is a 25-car garage. It would be used to house the property owner's antique car collection. Probably hard to see from here, but in the upper left-hand corner, there is a bathroom, so plumbing is included in this proposal. The building would also have electricity, a pressure washer, an HVAC unit, a hot water tank, a water heater or furnace, and some other service bay equipment. The design of the proposed garage would be consistent with that of the main dwelling, utilizing similar colors and materials. Maybe it's hard to tell from this perspective, but most of the garage doors, and just a couple, are on the north side, but most of them are on the east side of the building. And this is important because it's primarily facing away from Kinney Lane, away from the neighbors. The lighting that is proposed is directly above those garage doors, as well as in the sort of deck or porch area, again, facing away from Kinney Lane, so staff does expect any visual or lighting impacts to be minimal. Staff also expects that any noise impacts associated with mechanical work that might occur in a building of this use would also be minimal, again, facing away from Kinney Lane, away from the neighbors. The proposed elevation of the proposed height of the building would be 32 feet. The maximum height in the HDR regulatory zone is 35 feet. Still, this would be roughly 6 feet taller than the existing barn and would have a much larger building footprint. I did want to note that staff was contacted by a neighboring property owner who is concerned about visual impacts, as well as potential commercial uses of the proposed garage. Staff did conduct a site visit to view the property from the surrounding area. Here's a photo from Kinney Lane. That right there is the existing barn, kind of in the left of that picture there. Here's a photo from a neighboring property. You can see it again, barns on the left. And then one more photo from the neighboring property. As you can see, the proposed garage would definitely be visible from Kinney Lane, would definitely be visible from neighboring properties. However, it's the opinion of staff that the additional height would be well screened by additional vegetation or by the existing vegetation. Additionally, there are a number of shrubs that are sort of at ground level there that will continue to grow and will further screen the site. And staff did consider requiring the applicant to plant additional vegetation to further screen the site. But due to the size and location of existing vegetation, there really just isn't space. Further plantings would likely be unsuccessful. Notice was sent to 37 affected property owners, and this item was reviewed at the South Truckee Meadows Washoe Valley CAB meeting on September 9th. The property owner I mentioned earlier was present and reiterated concerns relating to visual impacts and proposed commercial uses of the garage. The CAB members ultimately recommended approval with conditions. They recommended that we condition approval to limit the hours of operation of the garage to no later than 8 p.m., and that we include some sort of clause to ensure that the proposed garage would not be utilized for commercial purposes. However, commercial automotive uses are just not allowed in the HDR regulatory zone, so staff did feel as though these conditions were unnecessary. The agencies which reviewed this application did provide comments in support of approval. And there is one required finding in the Southwest Truckee Meadows Area Plan, deals with ensuring that the community character can be adequately conserved. Staff does believe that this finding can be made. We did look at some other detached accessory structures in the neighborhood, and there are a number of them in that neighborhood, although this one would be the largest in the close vicinity. However, 2.5 acres is the minimum parcel size for a parcel in the HDR regulatory zone, so theoretically, this parcel could be split into two, and a dwelling of a similar or larger size could be built in that exact location. So staff does feel that a structure of this size on a parcel of this size is consistent with the character. Staff was able to make the required administrative permit findings, and staff is recommending approval. This concludes my presentation. I'm happy to answer questions. The applicant's representative is also here and available for questions or discussion.
Thank you. Are there any questions? Mr. Stanley?
Yes, a question for the planner. Did you say that you had gone to the site?
Yes.
All right, and from the doctor's backyard,
Yes.
the sight line was not, in your opinion, a problem?
I actually met with the doctor on his property. This photo is from his property. This photo is also from his property. I mean, from here, I just feel like the vegetation and the trees, at least as far as the additional height goes, it would be pretty well screened. And I think that the views of the mountains would primarily be maintained. So the broader view shed, I think that those views would be maintained.
Okay. And from his point of view, or from a general point of view,
Yeah.
certainly considering his, is that removed deciduous tree, is that an issue? Was that within that sight line?
You know, it's really not. It's sort of on the other side of
Right.
the existing barn. It's right in where the property line sort of meets the pond. It's just a really large tree, and discussions with the applicant, they were amenable to replacing that tree.
Okay. And you mentioned replacing it with two other trees. But
Yeah.
is it required that they go into the same area that the one that's missing?
No, because that area would actually be built on. That would be where the retaining walls and the porch would be. And they don't have to be the same size. It's a really large deciduous tree, so the idea is replacing with two smaller trees would mitigate
So it's
that impact.
at their discretion where they place the new?
Exactly, anywhere on the 5-acre parcel.
Thank you.
I also believe that in your staff report that there's an existing barn there now, and if it's removed, the height of the new facility will only be 6 feet higher than the original one. Is that-
Yes, that is correct,
Okay.
with a larger building footprint,
Right.
obviously.
Mr. Sluse?
Thank you, Mr. Chair. In reading through the South Truckee Meadows Washoe Valley Citizens Advisory Board minutes, it refers to the garage will be 1,600 square feet with a second floor. So I just got to make sure in my mind that what was presented to the cab is the same as what's being presented to us here.
Yeah, so the footprint would be 9,000 square feet, and I think I could look at the square footage. I'm not positive off the top of my head, but the applicant might be able to answer the square footage question. Or no, the square footage would, I'm sorry, the square footage would be 9,000 square feet. But I'm not sure how to respond to that. That was what was presented.
Okay, who does?
The applicant, I'm sure.
Okay.
There isn't a second
We'll ask
story.
the applicant, thank you.
Yeah, there isn't a second story, so it's just a 9,000 square foot building. It's really tall.
Okay.
Because they want to have some room to sort of maneuver the cars around.
So actually, you just answered my question. So
Yeah.
there is no second story, so this
No.
is not the same thing that was presented to the cab.
I do not recall the exact number
'Cause
that was
that's-
presented to the cab.
The cab minutes are pretty different than what I'm seeing here. So I'll let the applicant try and explain it to me.
Hold on just one second, make sure, are there any more questions for staff? No? Okay.
Well,
Wait a minute.
excuse me. Is there, I don't see a condition prohibiting commercial use. Are you just using the zoning as being prohibitive for commercial use?
Right, yeah,
So
commercial.
if he is found to be using that facility for commercial purpose, he would be in violation?
Yeah, he would call, if a neighboring property owner thought that they were using it for commercial purposes, they could call our code enforcement. That would be a code enforcement violation.
Thank you.
Yeah.
I have one.
And Mr. Stanley?
I attended the CAB meeting, and I don't recall anyone using any other phrasing other than 9,000 square feet there.
I don't recall that either, so I'm
Yeah.
having a hard time
I
responding.
was wondering if perhaps there might be an error in the minutes, because it's the kind of thing, given that there were some questions, typically would have come up. So, and I don't recall it, so I was wondering if you did.
I don't recall that being presented either.
Any other questions? Yes, because it says within the project evaluation construction, 9,000 square foot detached accessory structure. And then the main dwelling, well, the main dwelling of the property is 10.8. Is that, are we talking two different things here, maybe? The main dwelling versus the,
Yeah, the main dwelling is 10,000 square feet, but the main dwelling has a smaller building footprint because it is a
because it goes
two-story
vertical.
building.
Right, okay. All right, thank you.
You're welcome.
Let's have the applicant come up and we can ask him a bunch of questions.
Yes, I'm John Matetich, architect. I think there was I don't think there was, the recorder wasn't there that evening, is that correct?
It was just a little, reporter device, but she was on there.
Yeah, I do mumble, so, but that is the 1,500 square foot is the existing barn, which is two-story. There's no, that's where the conflict probably came from. And does that answer your question? You know, we were always shown, the staff and everybody, that was always 9,000 feet.
Yeah, and that's fine. I just want to make sure that what was presented to CAB is the same thing that's being presented to us here.
That's correct.
And, you know, and I do see that there are further comments later on in the minutes that reference a much larger project. But, you know, it's pretty spelled out in this first paragraph that they're talking about 1,600 square feet. So it may in fact have been the existing barn, but as long as it was presented as 9,000 square feet to the CAB, the project itself, I'm okay with that.
Okay.
Any other questions? Thank you, sir. Appreciate that. Madam? Oh, we're going to probably get to you in just a second here. Let me just go in the order. Madam Secretary, is there anyone from the public wishing to speak on this matter?
We have Susan Baker.
Ma'am, did you put a card in wishing to speak? If you'll see the secretary, you can go ahead and fill out a card and we'll give you some time.
Hello, I'm Susan Baker. I live on the road just above the location that we're talking about. First of all, I don't care how you dress this up. This is not a barn-looking structure. This is a warehouse. And in our area, we don't have warehouses. In this area, this is a very deceptive picture. This is a picture taken at a very low location. The whole area slopes up from Kinney Circle. It's all gently sloping up the mountain. And that's where I live, right above that. So I love living there. I built my home as an owner-builder in 1990. The ruralness is beautiful. And if we start putting in huge structures that are bigger than the home that they live in, that is a warehouse. There is no way to hide a 9,000 square foot structure. I don't care how many trees you put there. None of them are as tall as the 9,000 square foot. structure. And the trees that you're seeing are very mature trees. They've been there for a long, long time. And that picture is not of the 9,000 square foot structure, which I should be calling a warehouse. To approve this kind of project, a warehouse in a very rural, very neighborhood area, would be the start of a destruction of an area, because other people would see that and use that as an example of something that they could possibly build. Although I doubt that anyone would do that, because we're all there for the rural beauty and this pocket of uniqueness settled right in the middle of everything going up big time around us. So when you drive out between Huffacre and Holcomb and you look west, you're in the country and it's magical. And people are absolutely amazed that this area exists within the city limits. And so I'm begging you not to approve this project. This picture is not worth 1,000 words. It's not accurate. It doesn't explain the whole neighborhood. And I'm just trying to get in all of my points that I jotted down. No, I just say that it is a gorgeous area, and don't change it, please. And it's all built out as much as it needs to be. There is no room for more lots, nothing. So this is it. Thank you.
Thank you. Madam Secretary?
Next, we have Carol Tripp.
I'm sorry, I did not come prepared to make any statements, but my husband and I live on Kinney Lane, 2185, which is directly across the street from where the structure will be. I can't imagine a garage full of antique cars, I'm sure are very expensive, in our neighborhood. I'm sorry, it looks like a garage. It didn't look like part of a house to me. My husband has antique cars, and he wouldn't dream of bringing them up and putting them on our property. He's got another garage that he uses. I hate to lose the integrity of our property out there. The lots are large. That's what we all wanted. The houses are fairly big. Hate to lose it. Thank you.
Thank you. Madam Secretary, anyone else wishing to speak on this matter?
We have no further public comment.
Okay, we'll go ahead and close public comment and bring it back to the board for discussion. Mr. Stanley.
As I mentioned, I attended the CAB meeting, and the concerns there from the citizens were around hours of operation and the fact that they were concerned that it would become a commercial enterprise. It sounds as if zoning restricts any kind of commercial activity and consequently hours of operation behind that. And I'm, again, to Mr. Toulouse's issue, I think it was clear throughout the CAB conversation that it was a 9,000 square foot structure, and thus the concerns about height and so forth, and sight lines.
Thank you. Mr. Toulouse.
Thank you, Mr. Chair. I have some concerns that are similar to Mr. Stanley's, but I just, in looking at the overall plan, the building footprint in the area, I just don't think this particular site is suitable for this big a project. I think it's too big. I think 9,000 square feet and the height of the structure, it's too much in that area. The site is not suitable for it. And I also find that were we to approve this, I think it would be detrimental to the other property owners in the area. That's my take.
Thank you. Ms. Hill, do you want to?
I
Take a shot
agree
at
with
this.
Mr. Toulouse. It looks like a warehouse or it doesn't, it could be similar in size and less obtrusive, I think. In relationship to the existing structure that's there, I think it would be a detrimental to the neighborhood.
Thank you. I'll take a stab at this also. I've looked at the picture that shows the existing barn, and then, of course, the artist rendition of it, and I mean, they look pretty similar when you're comparing the pictures. The problem with that is that it's really not to scale. The barn itself, I believe, the existing barn was 3,200 square feet. That's going to be demolished, and this thing's going to be 9,000 square feet, which is roughly 3 times the size of that existing barn on that property. I tend to agree with Mr. Toulouse as to the issuance not detrimental in regards of changing the surrounding characteristics of that area. It is going to house, it is a warehouse, it is going to house 25 vehicles sitting there on the property, and I'm not too sure that that I can approve it based on really site suitability and issuance not detrimental. With that said, is there any further discussion?
No, other than to say, I don't think it's appropriate in a residential neighborhood. That's kind of my bottom line.
Thank you. Well, with that, I will accept a motion.
Mr. Chair, I'll take a stab at it.
Thank you, Mr. Toulouse.
I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Board of Adjustment deny administrative permit case number WADMIN 19-0016 for Mr. and Mrs. James D. Martini, having been unable to make all 5 findings in accordance with Washoe County Development Code Section 110.808.25. The findings I am unable to make are those of site suitability and issuance not detrimental.
Thank you, Mr. Toulouse.
And not quite done, in accordance with the Southwest Truckee Meadows Area Plan.
Thank you. Is there a second?
Second.
Second, Ms. Hill. All in favor?
Aye.
Aye. Motion passes unanimously.
Mr. Chair, if I...
Mr. Lloyd, would you please give the appeal procedure?
You bet. Most decisions rendered by the Board of Adjustment are appealable to the Board of County Commissioners. If you disagree with the decision of the Board of Adjustment and you want to appeal its action, you may do so in writing within 10 calendar days from the date that the decision being appealed is signed by the Secretary of the Board of Adjustment and mailed to the original applicant in the proceeding being appealed in accordance with Washoe County Code. Please call the planning staff immediately at 328-6100 for information on the appeal procedure and application fee.
Thank you. We'll move on to the next item, special use permit case number WSUP 19-0017, Cold Springs Elementary grading. Any disclosures from the board?
No.
Thank you very much. I believe Ms. Kirschman, you were up again.
All right. Okay, this one's a special use permit to allow for grading to facilitate the construction of the Cold Springs Elementary School. The site is located just northeast of the intersection of New Forest Drive and Briar Drive in Cold Springs. Washoe County School District did consider 7 alternative sites, and then after an extensive public outreach process, the site was ultimately determined to be the preferred location. Overall, the project consists of grading, construction, and landscaping for a 745-student elementary school. It's located in the medium-density suburban regulatory zone, and public schools are allowed by right in this zone and in most zones in Washoe County. However, the grading does trigger the major grading thresholds, thereby requiring the special use permit. Overall, the entire site, roughly 10 acres, will be disturbed or graded during construction. This includes roughly 1,620 cubic yards of excavation. That excavated material will be used on site, and an additional 93 cubic yards of fill material will be imported as well. Here's a photo of the site. So as you can see, it has already been mass graded as part of the approved tentative map for the Woodland Village development. So the site is pretty flat, and the proposed grading today is pretty minimal. I wanted to hone in on the playground for just a second. This special use permit is a little bit nuanced. So per Washoe County Code, on an area that has a less than 15% slope, any grading under a future building or landscaped area or parking lot does not require special use permit approval. Only those areas that will remain undeveloped require special use permit approval. So in this case, the only part of the project we're really reviewing today is the grading associated with the playground, which will remain undeveloped per Washoe County Code standards. The playground comprises roughly 26% of the overall site, or 114,000 square feet. It will be covered in a minimum of 4 inches of decomposed granite, or DG, and that's consistent with many other schools in the Washoe County School District. Here is the overall site plan. Pretty hard to see, but the proposed grading will result in less than 15% slopes, and those slopes will be controlled through the utilization of best management practices, or BMPs, during construction. Those BMPs do include a dust control program, watering of open areas, obviously conforming to all Washoe County air pollution regulations, as well as temporary and long-term stabilization of any disturbed areas. As I mentioned before, the site has been mass graded. There's minimal elevation change. It generally slopes from the northeast to the southwest, with an elevation change of about 6 feet. So pretty flat. Some on-site grading or on-site drainage improvements will capture on-site flows and move them to an off-site facility that's located to, or not a facility, an off-site drainage improvement, I should say, that's located to the west of the school site. Here's a photo looking along the eastern border of the site. You can see a number of trees and some existing vegetation there. To mitigate any impacts, visual impacts associated with the grading for this playground area and then the future playground, all existing trees will be maintained, and an additional 147 trees will be planted along the border to screen the site. A number of shrubs will also be planted. To mitigate noise impacts, the conditions of approval would limit the hours of grading operations as well. And the notice was sent to 92 affected property owners, and this item was reviewed at the North Valley's CAB meeting on September 9th. They voted unanimously in support of approval. The agencies that reviewed this also provided conditions in support of approval. Staff was able to make the required findings. Again, today we're really only considering the grading associated with the playground. So not the whole school, not looking at traffic or circulation signage, those things. And staff is recommending approval. Here's a possible motion. I'm available for questions, and then the applicant's representative is also here and has a brief presentation for you as well.
Hey, are there any questions?
No.
I've got one. If you're just going to grade it, how does it become a playground? It's just a graded lot.
Put in some DG on top. I guess that's pretty consistent with other schools.
Being a little bit facetious.
Yeah.
So, thank you.
You're welcome.
Is the applicant present and wish to speak on this matter? Or the representative?
Thank you very much, Mr. Chairman. Board members, for the record, Andy Durling with Wood Rogers, representing the applicant on this, Washoe County School District. Staff gave a very comprehensive overview. I won't, there's some redundant slides here, so I'll skip through a few of them. Effectively, as staff stated, it is a little nuanced. It comes down to the fact that the outdoor play area remains with decomposed granite covering it as a ground cover. If that area were to be formally landscaped, i.e., or for example, plants and shrubs or trees and shrubs were included in that, then we wouldn't be here. It would be considered formal landscape area. In the context of how Washoe County School District builds elementary schools in particular, those areas are left as kind of undeveloped free play areas, playground areas, and that's kind of the nuance to why we're here today. So 26% of the site will remain as kind of that flat multi-purpose field area. If we were under 20%, we wouldn't be here also. So it's just kind of a little function of code that we're here today. And sorry, these are some other schools just pulled. A number of schools in Washoe County are developed in this manner. Here's 4 of them across the county that have that kind of DG field area as part of their multi-purpose field.
This exhibit highlights that area. The 26% is highlighted in yellow, so it'll have kind of the play structures incorporated in there, and the remainder of it will have a decomposed granite covering it. We are in agreement with staff's recommendations and the conditions as presented, and would be happy to answer any questions. Thanks.
Thank you. Any questions? Mr. Toulouse?
Thank you, Mr. Thomas. This is for you. And this really has nothing to do with what you just presented, but I would really love to see the Washoe County School District set aside a little bit of property in every one of these schools, these undeveloped areas, to be restored as a natural area, maybe like a half an acre, quarter acre, wildlife habitat, community garden, something like that. That's just my only personal input, and I'd really encourage you guys to do that. Thank you, Mr. Chair.
Thank you. Are there any other questions for this gentleman? Mr. Stanley?
Thank you, Mr. Darling. How does leaving this open work with the Washoe County Engineering item F in their conditions about using palliatives? Obviously, they don't, I wouldn't think you'd use it on DG or crushed rock, but.
Sure, so no.
What are the mechanics there, please?
Representative from Odyssey Engineering, who's the engineer on this, can fill in the gaps here, but effectively, the DG is provided, and I believe it's a 6-inch cover, so it is considered a ground cover. It addresses any dust control or anything like that, and would be left in that state. I don't believe any dust palliatives would be added to the DG after that. So due to the depth of the DG that's placed, it does qualify as being a permanent ground cover that would qualify for air quality, things like that.
Is the shorter version that it meets the stipulation here?
Correct, yes.
That's correct. Frank Beard with Odyssey Engineering.
Go ahead and step up to the mic and go ahead and state your name again.
Frank Beard, Odyssey Engineering, and yes, it is considered a dust palliative. So it's just a condition to keep the dust from moving out there. That's all it is.
All right, thank you.
Okay, no more questions. Thank you. Madam Secretary, anyone from the public wishing to speak on this matter?
We have no public comment.
Thank you. We'll go ahead and bring this back to the board for discussion. Any discussion? No? Yes? No? Okay, if there is no discussion, I'll accept the motion.
Okay, go ahead.
Thank you. Mr. Chair, I'm prepared to make a motion. I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, Washoe County Board of Adjustment approve with conditions special use permit case number WSUP 19-0017 for the Washoe County School District, having made all 5 findings in accordance with Washoe County Code Section 110.810.30, those being consistency, improvement, site suitability, issuance not detrimental, and no effect on a military installation.
Thank you. Is there a second?
Second.
Ms. Hill, second. All in favor? Aye.
Aye.
Motion passes unanimously.
Don't forget that wildlife habitat.
Good idea.
Next item on the agenda, special use permit case number WSUP 19-0014, Columbia Hill Grading. Ms. Bronchick, you're up, sir.
Good afternoon. Chris Bronzick, Washoe County Planning. So we're looking at WSUP 19-14. This is Columbia Hill Grading. So the application is requesting a special use permit for major grading of an area of approximately 131,000 square feet. It's roughly about 3 acres. Additionally, they're proposing 4,031 cubic yards of cut and 4,147 cubic yards of fill. It's located at 120 Columbia Court, which is located off of Red Rock Road, north of the Stead Airport. So additional factors which cause this to come in for an SUP, special use permit, are the 2 grading thresholds that I have listed above. So the first is grading of more than 2 acres on slopes in excess of 15%, and any driveway or road that traverses any slope of 30% or greater. So this lot is a relatively steep lot, and currently it is undeveloped. So the applicant, I've provided a site plan for you. They are proposing a pretty significant driveway. And the driveway is there for the use of a single-family residence, a pole barn, and a proposed future phase horse arena. So one thing to note about this site plan, if you look towards the lower left, you'll see a solid line, and that indicates where an existing, I suppose, a legally graded driveway was done prior to the applicant purchasing this property. And so the proposal right now does not follow that, but they are proposing to allow for revegetation to occur and to ensure stabilization. So one thing about this lot, because it is naturally vegetated and the topography of this lot, much of the proposed grading is not visible from surrounding properties. We did take a site visit to this location, and from the public right-of-way, we were unable to see much beyond probably about 100 feet. So public notice was sent to 41 property owners, and this was presented to the North Valleys Citizen Advisory Board on September 9th, 2019. The project was recommended for approval unanimously. So a special use permit has findings for consistency, improvements, site suitability, and issuance not detrimental. Staff was able to make these required findings. These findings can be detailed on page 8. Staff is recommending approval with conditions for this special use permit, and I've provided a potential motion for you on the screen above. I'm happy to answer any questions you may have.
Actually, I do have a couple. What is the distance of this? Maybe I need to ask the applicant this, maybe if you don't know, but what's the actual driveway distance?
Do you have that?
Okay, we can get to him in just a minute then. And then what was the slope? You said it was over 15%?
So much of the site is over 15%. There are specific locations that are anywhere from 22% to 30%, so they are quite steep. In terms of that steepness, this was reviewed by our engineering department. They did not have any concerns. They did not present a motion for denial. They conditioned it appropriately to allow for an approval recommendation.
And you also stated that this is basically for the roadway, but there will be a arena and a horse arena and a barn will go in sometime in the future?
That is correct.
Is that part of this?
So the grading aspect to build or create the paths is part of this application. However, if the horse arena is larger than the single-family home, they will have to come back for an admin permit. Additionally, there's still timing related to a special use permit. So if they do not phase it in an appropriate manner and this horse arena and pole barn do not get constructed within that time frame, I believe it's 2 years, then they have to come back for a secondary grading permit to permit that area. But this one currently permits it all.
Okay. Thank you. Mr. Stanley?
Thank you, Mr. Chair. Planner Bronczyk, a question for clarification for me. Is it the roadway that has a certain elevation issue, or is it the site itself?
So my understanding upon review is the site itself.
Okay, so the elevation of the roadway, let's say, is less than 12%, but the site is 25, 30 in some places. That's what calls by code for an SUP in this area?
Yes.
Okay.
So there is no 30% slope for a driveway.
It'd be kind of tough, yeah.
But the site itself in what they're trying to traverse, there are portions that would hit that 30%.
All right, thank you. And the follow-up question was, what was the gross square footage of, or cubic feet of earth to be moved that triggered the SUP in that regard also?
So actually, what triggered the SUP was the square footage over that 15% threshold, and then the driveway that is traversing that 30% or greater slopes.
Okay, I thought there were two, one that identified how many, the amount of earth being moved that you indicated earlier.
4,031 cubic yards of cut and 4,147 cubic yards of fill.
Thank you.
This is going to be more of a statement than a question for you. I know in the past, when we've dealt with these type issues of someone wanting to put a single-family residence up on a hill, the Truckee Meadows Fire Protection District has said if it's given over a certain length, i.e. 150 feet or over 200 feet, and the slope is over 15%, the road driveway has to be a certain width and has to have pullouts. But I've also noticed that there's nothing from Truckee Meadows Fire Protection District that's addressing this. And I know we had it, I believe it was the Houston one, that we talked about the grade and all that. And I don't need to get too far afield here, but I mean, I just find it interesting that we seem to be missing that under these set of circumstances, where in the past, I know they've given us that information to work with, the Protection District has, so.
I understand what you're saying, and for the record, this was routed for agency review to Truckee Meadows Fire Protection District. We did not receive any comments back from them.
Right.
I do not know fire code, so I wouldn't be able to speak to that.
I believe I know about that much, what I heard during testimony at one time. Mr. Lloyd?
Yeah, when this the set of grading plans comes to the building department, it will be routed to Truckee Meadows Fire, and so they will have an opportunity to approve it. And they'll have to approve it, yes.
Okay, excellent, thank you. Any more questions for staff? No? How about the applicant? Would you like to come up and address the board?
Yes, good afternoon. Derek Wilson with Rubicon Design Group. I sent there we go, great, thank you. So Chris did a thorough job, and I appreciate the questions, so I'll do my best to keep this brief. I think people are familiar with the site. Special use permit to allow for grading and a horse arena. I'd like to stress that the horse arena is for family use. It's not a commercial operation. They have no interest in making this a commercial venture. It's similar to a lot of residences in the area on larger lots. People like to have horses and somewhere to exercise them. So there is an existing roadway or driveway built by a former owner. Chris pointed out that we don't follow that alignment exactly, and there's a reason for that. That old roadway was not done with any engineering oversight. It was just informally, somebody with a bobcat probably went out there and just rode up and down the hill a few times. The good news about that is that informal roads tend to end up predominantly in logical places. People don't climb steep hills if they don't have to. So we can utilize a lot of that existing alignment. We can minimize any additional disturbance by using some of that alignment where it works. Where it makes more sense to adopt a more sophisticated design, we'll deviate from that layout. We'll adhere to engineering code. We can keep the roadway to acceptable steepness, but that does involve some additional grading. So the old road, obviously not built to any sort of design standards. You might get erosion problems. You might have sections that are too steep. I don't know exactly, but we do know it wasn't built with any sort of review. So this project will bring that road into compliance. I think that's an important point. There's a lot of informally graded roads in this area, and I like to see those get cleaned up. That's the site plan. I'd say it's important to look at this from, yes, we're disturbing roughly, I believe your question, Mr. Stanley, was what's the total disturbance? Roughly 3 acres. On the other hand, it's a large lot, it's 55 acres, so the road is certainly the minimum length to provide normal access to a house. The horse arena area, that's coming in a second phase. The reason for the phasing is that if you're not a property developer, this is a substantial project. This would be a big project for any one of us to take on. So they want to focus on the house first, not have to come back for another special use permit if they, or when they do the horse arena. So that's why the simple phasing is in place. But building the house first is more than enough for most families to take on. So 2 phases. The project is highly consistent with other development in the area. It sort of matches the theme and the design standards of the area. And as Chris mentioned, not visible from surrounding property. So I believe it's a fairly low impact project. And if people had additional questions, I'd be happy to talk further. Thank you.
I have a quick question for you.
Sure.
What's the distance of the road?
Thank you. I'm sorry, I don't have an exact figure. I estimate it to be about 1,500 feet.
1,500 feet, yeah, okay. And my only other question, I don't know if it's a question, but a concern I have is the barn and the horse arena to be completed at a later time, that's kind of in perpetuity. So, you know, you're asking us to approve this, but you're gonna do the house and then maybe we'll get to the barn and the horse arena one day, maybe we won't. I mean, there's, you know, I'm a little bit concerned of the open-endedness on that side.
Sure,
So.
and I believe we have a time limit built into SUP approvals. So if they waited too long, it would expire.
Excellent. Any other questions? Thank you. Madam Secretary, anyone from the public wishing to speak on this matter?
We have no public comment.
Excellent. We'll go ahead and bring it back to the board for discussion. Any discussion?
Looks well thought through and well designed.
I agree, and I'm sure more people are going to get a chance to look this over anyway, so. With that, I'll entertain a motion. Ms. Hill.
I move that after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, the Washoe County Board of Adjustment approve with conditions special use permit number WSUP 19-0014 for Teru Langsdale, having made all 5 findings in accordance with Washoe County Code Section 110.810.30, including consistency, improvement, site suitability, issuance not detrimental or effect on a military installation.
Thank you. Is there a second?
Second.
Mr. Stanley, second. All in favor?
Aye.
Aye. Motion passes unanimously. Next up, special use permit case number WSUP 19-0015, Broken Hill Grading. Ms. Olander, I believe she gets this, or she did get this, or maybe she doesn't.
Chris.
Chris, come on up.
So, my understanding right now, as Trevor mentioned, due to staff shortages, she's upstairs, so she should be down here very shortly.
Okay. Well, if we want, we can move on to the next one and come back to this.
Yeah, let's do that.
Oh, wait a minute. Timing's everything. See, we're getting efficient here, so.
Too many, not enough planners.
No, you're up, Julie.
Ms. Olander, welcome to the podium. We're talking about the Broken Hill grading, so.
I'm Julie Olander for Planning and Building. This is a special use permit for Broken Hill grading. The applicant is requesting a major grading to grade approximately 2.5 acres, 8,871 cubic yards of cut, and 7,680 cubic yards of fill to construct a 1,600-foot-long access road for a water tank. The site's in a sort of a remote area. It's Broken Hills subdivision area. And the road is being graded to locate a water tank there for the Broken Hill development. Approximately 2 acres will be graded for the road and ½ an acre for where the tank will be sited. The material will be balanced on site. There shouldn't be any importing or exporting of material. and the road will be paved and then dedicated either TUMWA or the HOA. Here's a sort of a look. You see where the grading's occurring. There is some 2.1 slopes involved on this grading. However, because the site is over 5 acres and is more than 100 feet from the, oh, I apologize for my spelling error there, form instead of from, but it's 100 feet from the property line. And a building permit will be obtained when the water tank is going to be constructed. Public notice was sent out to properties within 1,000 feet of the site. It was presented to the Spanish Springs CAB on September 4th and was recommended for approval. Various agencies have reviewed the application, which is included in your staff report, along with the conditions of approval. I was able to make the findings, and I provide a recommendation of a possible motion. Also, the applicant is here and available for questions.
Thank you. Are there any questions for staff? None? Thank you. Is the applicant present and wish to speak on this matter? I appreciate that. Madam Secretary, is there anyone from the public wishing to speak on this matter?
We have no public comment.
Ms. Olander, can you come back up here real quick? We did get one email or letter in from an individual that had a little bit of a concern talking about the two different parcels, and I guess we've talked about the 262-acre parcel.
I think is that a different, Boneyard Flats grade? That's a different project.
Too many Bs.
Okay, hang
Broken
on.
Hill.
Number 16, right? Eh, never mind. Thank you. I appreciate that. Been a long day. Ready? Okay. My mistake. Thank you very much. And Madam Secretary, was there anyone from the public wishing to speak on this?
We have no public comment.
Thank you kindly. Go ahead and bring it back to the board for discussion. Mr. Stanley?
Yes, may I ask the applicant a couple of questions, and they can be long distance or?
No, let's have him come to the podium so
right.
we can hear his answers. What the heck is?
Carl Matzel for the record. I'm with Matzel Development Consultants.
Yes, Mr. Matzel, these will be easy ones, and thank you for the walk down. Just wanted to, perhaps a little bit of information about the tank. It is going to be serving what area for what distance, would you say?
The roadway is 1,600 feet. The elevation of the tank is 100 feet higher than the highest home. The tank will be serving 170 units in the Broken Hill subdivision only.
Okay, so it's not broken down, 170, you say?
It's 170 units.
Okay.
That tank is specifically will be built for 170 units.
Understood. So, and the transmission line, can you talk a little bit about that?
12-inch ductile iron pipe.
Okay.
And it'll be deeded, it's infrastructure that we will build, place, but that we'll design, construct, and dedicate to TUMWA.
There was a question.
Along with the tank.
Perfect. There was a question earlier in an earlier project about the length of a driveway and slopes and so forth as it related to fire issues. You've mentioned the length. What are the grades?
1,600 feet. The length of the roadway from the subdivision is 1,600 feet.
Right, and the grade is?
The Truckee Meadows Water Authority design guidelines give us the ability to grade a roadway at 12%, but they have internal policies to keep the roadway down to 10%. The roadway does not exceed 10%. The access roadway to the tank does not exceed 10%.
Thank you very much.
And when you talked about the tank pad and then the wall height, it said maximum stacked wall height 4 feet to 6 feet at the tank?
Yeah, it's 4 to 6 feet. Right now, it's designed, it's designed at 4 feet right now. If something changes, I just wanted to be sure I could get it up to 6 feet.
And stacked wall meaning?
It could be, keystone wall, stuff like that.
But that maximum height would be no higher than 6 feet is what you're planning?
That's correct.
Thank you.
And that's around the tank.
Right. Thank you. Any further questions? Thank you, sir.
Thank you.
Appreciate that. Okay, we'll bring this back to the board for discussion. Any discussion? With that, I'll entertain a motion. Mr. Toulouse.
Thank you, Mr. Chair. Excuse me. I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Washoe County Board of Adjustment approve with conditions special use permit case number WSUP 19-0015 for Barker. I might be reading the wrong thing here. No, that's right. Sorry about that. Barker Coleman Investments, having made all 5 findings in accordance with the Washoe County Code Section 110.810.30, those being consistency, improvement, site suitability, issuance not detrimental, and no effect on a military installation.
Thank you. Second. Mr. Stanley, second. All in favor?
Aye.
Aye. Motion passes unanimously.
I got out of order.
All right, let's see where we're at here. Next up, I believe it to be administrative permit case number WADMIN 19-0018, Herbert Garage. Mr. Pelham.
One moment, please. There we go. This is an administrative permit to permit a detached accessory structure larger than the main dwelling unit. This is a request by Mr. Abear for a 2,400 square foot garage on a parcel with a main dwelling of 1,152 square feet. This is located in the North Valleys area as shown here. It is on Sitka Street, just west of Matterhorn. The yellow area here shows where the garage is proposed to be located in reference to, it's a bit light, I'm afraid, but the existing dwelling and 2-car garage there towards the bottom, which would be the south of that parcel. This lot is flat, it is regular, it's a rectangle. The proposed garage is going to be red with white trim to match the existing dwelling and the existing detached garage. As you can see there on the right, the garage would be placed essentially behind that 2-car garage, and there's mature vegetation there, and it would be screened from the street by the existing garage and the existing dwelling. Notice was sent to the surrounding property owners as required by code. This was heard by the Citizen Advisory Board in September, who did recommend approval, with really very little discussion. This was sent to all of the appropriate agencies for comment. No concerns were expressed. On page 8 of your staff report, you have each of the findings as well as staff comments. I believe that all of these findings can be made. This is thankfully a relatively simple request, in my opinion. Again, we had no recommendations for denial, and I am recommending approval. With that, there is a motion on the overhead and included in your staff report, and I'm available for any questions that you might have.
Thank you very much. Any questions for Mr. Pelham? Mr. Stanley?
Thank you. Roger, did you have a chance to look at the surrounding area? And are there other structures similar to this in that area, given what we heard earlier today?
Yes, sir. Thank you for the question. I did. I'm familiar with that area. When I went on my site inspection, I drove around the block and a little bit just to get a feel for the area. Large detached accessory structures are relatively common in that area, be they barns and workshops and whatnot. Some of them that were done prior to the current code going into effect that maybe don't match the existing dwelling particularly well. In this case, we have a proposal for one that does match.
Thank you, Mr. Pelham.
Any more questions? Thank you. Madam Secretary, is the applicant present wishing to speak on this? Come on up. Shouldn't really have to ask Madam Secretary for that. I should just ask the applicant, huh?
Scott
I'll do
Aber.
better.
Scott Aber, owner, property on Sitka. Just wanted to state that this has kind of been a dream of mine. I've been working on it since I bought the property. I've been fixing it up. It's coming out really good, and I like to dream for the future. So down the road, if I get an RV or anything, I like having everything inside, and I like having a tidy yard, which looking around that neighborhood, there's quite a few that aren't so tidy. So I'm hoping to bring some improvement to the neighborhood. And that's pretty much all I have.
Thank you. Any questions for this gentleman? Thank you, sir. Appreciate that. Madam Secretary, is there anyone wishing to speak on this matter?
We have no public comment.
Thank you. We'll bring it back to the board for any discussion.
Looks like a fine project.
Excellent. With that, I will accept the motion. Mr. Stanley.
I move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Board of Adjustment approve administrative permit case number WADMIN 19-0018 for Scott Aber, having made all 5 findings in accordance with Washoe County Development Code Section 110.808.25, including consistency, improvements, site suitability, issuance not detrimental, and effects on a military installation.
Thank you. Is there a second?
Second.
Ms. Hill, second. All in favor?
Aye.
Motion passes unanimously. Next item on the agenda is special use permit case number WSUP 19-0016, Boneyard Flat Grading. Mr. Pelham.
Good afternoon, or perhaps even good evening, Mr. Chairman. To close out the day, we do have a special use permit, again, for major grading, this time in the Spanish Springs area plan. Yep, it'll be here in just a half a second. There we go. And this would be in the Boneyard Flat area. Again, this is sort of in North Spanish Springs, sort of just south of the Pebble Creek subdivision. The request is for excavation of approximately 500,000 cubic yards of earth and material. Now, this would happen in several phases over probably several years. And what would happen is they're taking some of the material out. They're going to stockpile the topsoil on site, use the good material underneath for fill in the adjacent residential and industrial area where fill is needed. And then at the end, that topsoil would be put back down. This would be permanently stabilized. We have some conditions to require that the finished slopes be 4-to-1 or shallower. That's shallower than we would typically allow at 3-to-1. That those finished slopes would have some curvilinear contour, that is to say, to mimic a more natural hillside. It is, again, located here. Now, and this has been a point of some confusion with some of these surrounding property owners. Those 2 parcels as shown are completely on the west of and then to the southwest of the Pebble Creek subdivision. The grading, however, will only take place on the southern portion, so really only to the south, slightly to the west, but primarily to the south of that subdivision, and only within this area that's shaded yellow. As you can see, this is a relatively flat area. A relatively large amount of material will be coming out, so when it goes back in, again, it will be relatively flat. Large area, but fairly shallow in terms of the grading itself. And again, this is an overhead showing that area. The perhaps primary or co-reason for this project is to increase the flood capacity of the Boneyard Flat area. As the dirt goes out, that simply means more water can stay there in a flood event. Some of the standards that are being applied are a 50-foot buffer between any grading and the adjacent property lines, which is actually going to be a little bit further than it is to the homes. Again, 4-to-1 slopes, that's very shallow. Mimic the natural contour at the end. General compliance with all the grading codes. And that would include things like dust control and stabilization, things of that nature. Now, notice was sent, again, you can see where, to the north there, the north part of this project, it is adjacent to the west of most of these, but again, the grading is to the south. But we sent notices to 159 property owners. Was reviewed by the Spanish Spring Citizen Advisory Board in September. They did recommend approval, noting the benefits of the flood mitigation and that no grading would be done on the northern part of that parcel. The northern part of that parcel is substantially steeper. It has more topography than the lower part where the excavation is proposed. This was sent to the appropriate reviewing agencies. We had no recommendations for denial. We did receive a request from the applicant, and we would like to recommend a revision to condition 1C. The applicant had a different reading of the code than staff did. And instead of saying the applicant shall submit complete construction plans, when we say complete construction plans, what we mean is plans that have all the necessary information for review. And so that's what we have added there, simply to make that clarification. With that, the findings and staff comment are included on page 8. I believe that all of those findings can be made. And with that, I am recommending approval. There's a possible motion there, and I'm available for any questions that you might have.
Thank you. Mr. Toulouse.
Thank you, Mr. Chair. Roger, can you go back to that modified condition, please?
Yes.
All the information necessary for comprehensive review.
So that's in my view, a pretty significant change from the language we've been used to seeing on these applications for a long time. So why the change? Is it just because the applicant asked for the change? I'm a little concerned about the change in language. They don't seem to mean the same thing to me.
The applicant had the concern that complete construction plans could mean that they had to complete the project within that 2-year time frame. That's not what it means. What it means is complete plans that have all the information that we need so that we can review. In fact, we have a condition of approval that gives a longer time frame, but we need the first set of plans in within 2 years. We know that this project is going to last longer than 2 years.
So why'd you change it?
Because I didn't feel that it made a substantive difference and to accommodate the applicant.
Okay, thank you.
We're not dealing with kind of semantics here, are we? Is it really?
I believe we are.
Okay, it's kind of where I was going, but if we leave it as is, does it change anything? I mean, if you're looking at complete construction plans, that would have to be, you know, the information necessary for you to conduct a review.
I tend to agree with you. I have, as you well know, written this condition or copied and pasted into a staff report on many occasions. Again, the applicant's concern was that someone else later down the road might try to read that in that the project must be complete within that time frame.
If I can add anything too, and Roger's correct, this doesn't change the condition. It provides more clarity, and actually moving forward, this is probably the language I think we want to start using. It's just an improved language.
So you would be in favor that now and into the future, we change it to indicate this?
Yeah.
All right. Mr. Stanley?
As long as everybody wants to be an art director. If you use both words, what would that do?
Give me a moment, please. Mr. Chair, I don't believe that that would change substantially. It might be a touch redundant, but I don't see it as being a detriment.
Doesn't make any difference.
Mr. Large, do you need to add anything here or not, sir?
Mr. Chairman, for the record, I believe that if you added both complete and with all information necessary for comprehensive review and by Washoe County, a reasonable person would interpret that as being redundant. I would also mention that now that it's on the record that this project will be extended longer than 2 years, I would guess that any legal basis that they would have for a finding that this was supposed to be completed within 2 years would probably be vacated by a jurist, but we're not at that position right now.
Thank you. Any more questions for Mr. Pelham? Mr. Toulouse?
Thank you, Mr. Chair. Roger, what is the distance, get back to it here. So from the nearest point of Pebble Creek, what's the distance to the proposed grading? So basically from the closest boundary point of Pebble Creek to the closest boundary point of where the grading is proposed, what is that distance?
Certainly. That would be, as I'm showing here on the overhead, in the northeast portion there, it's going to be 50 feet. That you can see sort of a little gap of 50 feet between the rear property lines of the parcels there, and then the beginning of that grading where it's sort of up on the slope where they would be taking some of that material, grading essentially from north to south.
Okay, thank you.
Mr. Pelham, I have a letter here in front of me from Brian Hamilton, which you may be aware of, and his concern was that this should be limited only to the 128-acre parcel 538-10-12. Is this exceeding that
Yes.
parcel by how much? Do we have any idea?
Yes, if I may. I apologize, but I'm going to turn my back on you for a moment so I can use the pointer. Okay, the pointer does not show up on those screens. I'm afraid to ask you to, if you can turn to your left and look at this one up here. Here's the parcel line approximately in this area. This grading here, I'm going to call that approximately a third of the area will be north of the one parcel here. And this is really where sort of Boneyard Flat, where most of the water is going to sit. That's the low point right there. And again, material will be taken out of there, stockpiled, material will be taken out of here, and when it's done, it's going to look like these contours here. So you can see it's going to go from a little steeper to here. This shows 3-to-1 slopes. Those are going to be 4-to-1 maximum if the recommended conditions are imposed. And then again, smoothing out here, and again, the water would pool in this area, increasing the flood storage capacity as well as providing good fill material.
So it's probably safe to say that it needs to be all-inclusive to really make it do what they're planning on doing to bring the water into the holding pond.
Yes, that is correct. Again, the grading serves the twofold purpose, and it's been designed to work as a project, to get the fill material and then let water go where it used to be.
Thank you. I just want to make sure this gentleman was heard also, since he was willing to write something to the board. So,
of course.
any other questions for Mr. Pelham? Thank you, sir.
Thank you.
Is the applicant present and wish to speak? How's that, Madam Secretary? Did I do that right?
Good afternoon, or maybe good evening. Jesse Ha, for the record, President of Hockel Properties, the general partner for Spanish Springs Associates Limited Partnership. Our family and partners have owned this since about 1915. And really in all that time, I'd like to give just a little background of why we're here and why we're doing this. This is a closed basin. Boneyard Flat is a closed basin, meaning at a certain point, the water goes there and it can't go anywhere else. It doesn't get back to the Truckee River. About 4 months ago, Washoe County staff came to us and said, you're no longer going to go on a 24-hour event of rainfall data, which is the datum we've used in doing all the flood control mitigations out there, and the business park, and the Pebble Creek, and everything else. They said, you're going to go from 24-hour to a 10-day event. It gave us a lot of consternation, and frankly, I'm a bit frustrated that engineering isn't here to give you this background themselves. But regardless of that, engineering has decided that they're going to go from a 24-hour event to a 10-day event, which will obviously increase the amount of stormwater that needs to be retained. Boneyard Flat's the logical place to put that. And so we're trying to partner with the county and trying to come out ahead and find a place to put that, knowing that part of the solution is simply to dig a hole or dig a bigger hole where the water naturally goes. And that's really the only place you're going to put it. The other thing that's going to happen is you're going to have to raise buildings as they come in. I don't know how much because they haven't told us. I believe the engineering has a plan and they know what it is, but they haven't told us. They thought maybe today, maybe last week, maybe the week before. Anticipated that number to be out before now, but it's going to raise the base flood elevation from an area of around 14 feet. They told me it could be 25 feet. So you're talking about buildings have to go up 11 feet, or you got to dig a hole to create that volume. So I believe as a good partner with the county, we're coming forward to try to find a place to put this material. I'm grasping at straws a little bit because I don't know how much volume is going to be there because they still haven't quite figured out how much water is going to be generated from that delta 24-hour event to a 10-day event. So that's a long way of saying, I don't know what we're going to move. And when Dwayne and everybody gets back to us, we can make a plan. But we acknowledge the county's got to have, or we as partners with the county have got a place to put this material. So that's why we were a little hesitant about condition, I think it was 1C. This isn't going to be a one-shop deal. This is going to be building X is going to come in. They're going to be required to mitigate so many cubic yards, or I don't know what the term is, but they're going to have to dig a hole, and then each person goes along is going to have to dig another hole. So it's going to take a while to get there. I want to compliment planning. They've been great on working with the standards. We think we've given some and taken some. And in all that, I have one more request that I'd like to ask of this body. If you approve this, I'd also like to request to extend the time we have for the special use permit on this grading. We have an existing grading permit in the business park. We've had it since 1999. We're still using it. So it's been about 20 years. So I'd request humbly to move the expiration of the grading plan. I believe that it's 1D, and it says it's going to expire in 2025. Sorry.
It does say that.
2025, we'd request 2038, 20 years. I don't know how long it's going to take, but I'm trying to help the county as much as help ourselves. So that's all I have. I appreciate all your time, and I'm open for any questions. Thank you.
Go ahead.
Thank you, Mr. Chair. Roger, if you could come back up. Thank you. Often in projects like this, and especially in projects like this, we see a condition of approval that relates to hours of operation. I don't see that here. Am I just missing it, or is it not here?
I didn't find it either.
Yeah, usually it's,
I'm sorry, if you look at condition 1H, it's not hours. It says grading shall take place during daylight hours only. That's what's provided.
which condition was that again, Trevor?
I'm sorry, 1H. 1H2.
1H2, sir.
Well, I got to tell you, I'm not comfortable with daylight hours only, because in the summer, daylight is from 6 o'clock in the morning until 8:30, 9 o'clock at night. I'm not comfortable with that at all. So I would propose to change that to an hours of operation from 7 a.m. to 7 p.m. That would make me a lot more comfortable. And then
Do you want it to be restricted on weekdays or weekends, or?
I would also, I would say, let's include Monday through Saturday and no work on Sunday. So I would like to include that into that condition. And then, thank you, Roger. That's all I had for you at this moment, anyway. And Mr. Haw?
Yes, sir, for the record, Jesse Haw.
Thank you. I'm very uncomfortable extending this SUP to 2038. I'll go 5 years to 2030, but I certainly am not going to go as long as you requested. To me, that's a really long time. This board will change by then. The county board will change by then. The code may change by then. I'm not comfortable going as long as you requested. So, I'm just spelling that out from my own standpoint that 2030 is as far as I'll go.
Understandable, thank you. I'd throw in one more thing. There's a good possibility this will be a total county project. They might just come in, dig out the volume, assess us. I don't know how they'll figure that out, but I understand your concern. I appreciate that. Thank you.
Thank you.
Thank you. Mr. Stanley?
Yes, I have a question for Planner Pelham. Yeah, thank you, Roger.
Yes, sir.
Do you have an issue with the 2030 extension?
No, the timeframe is well within your purview to determine, given your best deliberation.
Sure. All right, thank you.
Any other questions? Thank you. Madam Secretary, is there anyone from the public wishing to speak on this matter?
Yes, we have Angela Applegate, followed by Holly Cortez.
Thank you for your time. I live at the second home.
Can you just state your
where-
name again?
Oh,
just for
sorry,
the record?
Angela Applegate.
Thank
I live
you.
at 12225 Mystic Sands. I bought out here 3 years ago, well, a little over 3.5 years ago. Came out the year before, and it was a torrential rain that year. There's no flooding going on out there. Boneyard Flats gets about 2.5 feet of water every year. Since then, we have like a little quad to go right around out there, and it doesn't get a ton of water. It grows a bunch of nice little sunflowers. So I don't know why we need to suddenly dig all this dirt out and disturb all the wildlife, because I'm worried, because I did see online that it said there would be no environmental study. I think there needs to be an environmental study. What's going to happen with all the coyotes and the bunnies and all the birds? Are they going to disappear because they're going to dig out all that dirt? I think so. Just putting the fill dirt back in on top is not going to make all that wildlife come back. I bought out here for a reason. I have this big, beautiful Mystic Mountain right behind my home, and everybody out there did the same thing. I was the first house to ask them to open up that block because the builder wasn't going to open it for 2 or 3 more years. And I said, I'm going to move out here from Seattle. I want to be able to have all this beautiful scenery. I put 71 trees in my backyard just to add a little more greenery, and I'm worried. They're going to dig all this out, and all we're going to get to see is machinery running. I'm retiring in a couple of months. Now I get to listen to machines waking me up at 7 a.m. and run all the way through my day, and I have to have dinner listening to machinery run behind my house for up to 20 years? Are you kidding me? I don't think that's right. We have to worry about what we all got into. That was not on the plans. We knew it was all open property that could someday be built on. At no point did they say they were going to run machinery behind our homes for 20 years, because if that was the case, I would have never moved to Nevada. That's all I have to say.
Thank you.
Next is Holly Cortez.
Hi, Holly Cortez, 12025 Mystic Sands. I come at this from a little different perspective. We moved into Pebble Creek, and according to the information the HOA has been able to obtain, the developer, Spanish Springs Associates, did the drainage ditches in our association. The HOA has since had engineering reports done, and the drainage ditches aren't done correctly. They aren't going to drain into Boneyard Flats correctly. And they were supposed to initially be sprayed with vegetation. They were permitted, and the permits were never, the stipulations to the permits up to 15 years ago were never met. So now we're going to do Boneyard Flats with Spanish Springs Associates LLC, and the county's supposed to oversee this, and our home's back up to it. Okay, so my concerns are, we're going to do basically a retention pond, a storm drainage retention pond. My husband works for a developer. His company does these all over the country. Basically, what you're allowing the developer to do, and the developer, I believe, was probably in the original plan required to do the storm drainage retention plan as part of the development of the area. You're allowing him to space it out over time as he can find someplace to put the dirt. That's an inconvenience, I guess, to those of us that spent a great deal of money on our homes with the noise, with the dust, with the et cetera. But my biggest concern is that the county in the past didn't properly supervise the drainage ditches that were already done, and they don't properly drain into this retention pond that's supposed to be for storm drainage. And we're going to get into another mess. The association has gotten reports that it could cost the HOA, if we have to fix those storm drains, between $750,000 and $800,000. So now we as homeowners may have to pony up if the county doesn't help us. So I guess what I'm here asking for is, we want better supervision over what's going to go on than what we've gotten in the past, because right now, we spend a lot of money on our homes, and we kind of have a drainage mess because things were permitted and approved and they weren't done properly. So I guess we're just, I'm just here to ask for your help and your supervision, that we don't end up with an even bigger mess. And why extend this out? Developers all over the country have to build strange storm drainage retention ponds all the time when they develop areas. Why string it out over 10 or 12 years? Usually, counties require that they do it whenever they build.
Okay, Ms. Cortez, thank you very much.
Thank you.
We have no further public comment.
Thank you. We'll go ahead and close public comment and bring it back to the board for discussion. I'll start. I was just going to say, I tend to agree. I mean, I'm not adverse under these conditions of adding the additional language that Mr. Lloyd supports now and into the future. I do agree with Mr. Toulouse that 2038 is way too long out there, especially if engineers now demand that it be a 10-day event. Well, you might get one or two of those before the 30 years are up for sure. The question becomes okay, how far out do we allow this to go? And in so doing, obviously, we need to take into consideration the homeowners, because you're right, I wouldn't want to be out there 6 days a week carrying a bunch of heavy equipment going on and on. You would sure hope there wouldn't take 10 years of solid equipment going on and on and on. I doubt that it would, but still, it is gonna take some time to be done. The question is how much time do you allow for? That's kind of my concerns or my issues that I think we all have to resolve up here. Mr. Toulouse?
Thank you, Mr. Chair. I agree with you wholeheartedly, and Ms. Cortez has done a pretty good job of presenting her concerns, and I'm sure some of her neighbors' concerns as well. And I'm looking at that length of time, I'm willing to walk back my proposal to the existing 2025. And you know, if if in that 5-year period that's not long enough, then we have to come back. But I'm willing to walk that back to 2025. The other changes as proposed, I have some concerns about the 6-day-a-week thing. I do have some concerns about that, and I might be convinced to walk that back to 5 days a week instead of 6 days a week. The hours of operation, I think 7 to 7, while it will be certainly an inconvenience and cause some issues in the neighborhood, I think it's appropriate for the project. So I'm not willing to walk back the hours, but I am willing to walk back the days of the week if somebody would like to entertain that.
And walk it back to just the week?
5 days a week, weekdays only.
So Monday through Friday?
Yep.
Thank you. Mr. Stanley?
You know, I have a question about, just about standard operating procedure. Perhaps this may be for you, Roger. For operation, and I agree with everything being said, by the way, but what is 7 o'clock in winter? Or does that mean the machinery is using overhead lights, or how does that work? It's pretty dark where I live at 7 in the winter.
Truthfully, I would probably have to go online and look and see what time nautical twilight is in the depth of winter. I can't tell you that. I don't know. I'm sorry. But if we wanted to say daylight hours only and not earlier than 7 a.m. and not later than 7 p.m., perhaps that would address that concern?
Yeah, and I guess thank you. And I guess my question was, and I think you've answered it, but just to make sure, there are no standard hours.
Oh, in terms of the code for when machinery can take place, no,
Yeah.
we do not have that. Our noise and lighting standards are really not particularly applicable in this case. They really deal with sort of industrial processes that are going on 24/7, like in a factory or something like that, rather than sort of those intermittent sounds that come from construction type activities. So no, there is not a standard. That's why we would typically put this as a condition of approval.
Thank you.
I believe I've seen a 7 to 7 before, seems to be kind of a standard, but you're right, at night, you know, you wouldn't want them out there.
Well, I'm willing to
Give it a shot.
give it a shot. How about we do,
One second. I think
Sorry.
Mr. Stanley has one more question.
I do.
Go ahead.
And if you don't mind. Roger, again. Once, to address the lady's concerns about wildlife and so forth, which seem pretty valid, what is the intention about what the floor of this, as it's being dug and as it's completed? And I, by the way, certainly understand the requirement, and understand being between a rock and a hard place with the county and the recent issues about flooding. But what is the plan for doing something around the bottom of this, and will it be rabbit-friendly?
Absolutely. As a matter of fact, the plan is that those soils that are essentially wet right now, that have the vegetation and the seeds, that type of thing, are going to be stockpiled on site. And when this is done, they will be spread back down there in the bottom area. So those natural plants and seeds and things like that will in fact be reestablished at the end of the project. So I would say that environmental mitigation will take place, again, using the materials that are there now, because sort of that wet stuff that has all the vegetation is not a suitable material for structural fill material.
Okay. Thank you.
I think it's also covered within 3J, talks about revegetation and things like that. So
Yes.
within a given period of time, so. You okay with that too, or?
Yeah, no, I'm okay with that. I have a little bit of concern about noxious and invasive species. But I don't want to address that right now. The hours of operation thing, you know, I'm trying to think of a way to do it without making it cumbersome and overly complicated. And I think the best way to do it is just go 7 to 7, Monday through Friday. You know, I looked up some changes in dusk and dawn and nautical twilight on my phone here. That's the one thing the damn things are good for. But it would be crazy complicated. I mean, you know, from the month of May to this middle of June, it would be 6 a.m. to, you know, whatever. I think that we're better off just sticking with 7 to 7.
Or you could say daylight hours not to exceed.
We could do that, and Roger proposed that, so I'm willing to do that, daylight hours not to exceed no earlier than 7 a.m. and no later than 7 p.m.
Right, and in the winter, they would have to stop after the daylight hours, which,
Yeah, that's a good solution, I think.
public
Yeah,
comments over.
No, this is closed right now. This is amongst the board, so. Unless someone has, if a board member has a specific question, then we can call you back to the podium, but the public comment is closed, so. Are there any other discussions? So if I understand it, with the proposal is, we're looking at a couple different things here. One, we will change the language where the applicant shall submit completed constructions. We change that to the language that was already up on, presented to us up on the board. We would change the date to what, Mr.
My proposal is to keep the date the same as
2025.
October 3rd, 2025.
Okay, and then the operating hours from 7 a.m. to 7 p.m., not to exceed before 7 a.m. and not after 7 p.m., but predicated upon daylight.
Yeah, so it would read daylight hours no earlier than 7 a.m. and no later than 7 p.m.
Okay.
I think that captures it.
Everybody on the board?
It was Monday through Friday, yeah.
Yeah, Monday through Friday. Everybody on the board understand those?
Yes.
That we're kind of talking about? Excellent. Okay, well, with that,
I do have a question for Ms. Cortez.
thank you.
If you
Ms.
could
Cortez,
step
would you
back
please
up.
come back up to the podium for us.
In 30 seconds, what were you going to tell us?
Well, the other issue that we haven't addressed is mosquitoes. We're going to create a retention pond, and all of us are used to sitting out and enjoying our backyards. What is the county going to do on a regular basis for mosquito abatement? I'm from the south, so I tend to, I moved here to get away from mosquitoes, and I really enjoy sitting out. But that's all going to change once that retention pond's in there, if there isn't a plan to deal with mosquitoes.
Thank you.
Thank you.
And I can say that Washoe County Vector Control is really on top of mosquitoes. So I don't think that'll be a huge issue. And if it is, a couple of complaints to Washoe County Vector Control will handle it. So, thank you.
Okay. With that, I will entertain a motion. Who wants to give it a shot?
I think we,
I guess I'll take a shot at it. So before I take a shot at it, let me make sure that at this point, the only conditions that we have amended are, let me go back a page here. The language on
1C.
1C, yep, 1C and 1H2. Am I correct in that?
correct.
Okay.
Yes.
All right, so I move that after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, the Washoe County Board of Adjustment approve with conditions and with modified conditions 1C and 1H2 Special use permit case number WSUP 19-0016 for Spanish Springs Associates LP, having made all 5 findings in accordance with Washoe County Code Section 110.810.30, those being consistency, improvements, site suitability, issuance not detrimental, and no effect on a military installation.
Thank you, Mr. Toulouse. Before we go any further, Mr. Lloyd, we're all on the same page. We understand the changes that we've made or we're going to vote on?
Yes, we do, yes.
All right. Thank you. With that, I'll accept a second.
Second.
Mr. Stanley, all in favor?
Aye.
Aye.
Motion passes unanimously. Thank you. All right. But wait, there's more. Next is chair and board items. A, future agenda items. Does the board have any future agenda items they want to present?
No, thanks.
Thank you. B, any requests for information from staff?
No?
Okay, thank you again. Moving on, director and legal counsel items. Report of previous Board of Adjustment items. Mr. Lloyd? Anything for us?
No previous items to report on. I wanted to remind the board that Regional Planning Commission last week just approved the update to the regional plan. It was 2+ years in the making, and so now it goes on to the Regional Governing Board next Thursday, if you're interested. That's all I have.
Thank you. Mr. Large, legal information and updates for us.
Nothing from legal.
Thank you, sir. Madam Secretary, is anyone from the general public wishing to speak at this time?
We have no public comment.
Thank you. We are adjourned.
Yay.